Next year, 2, page 13 is the notice, my lord. Notice dated 7/8/2020, my lord.
You got it. Okay.
My lord.
Heard Mr. Vishal Vaibhav, London Council, appearing for the petitioner. This is a petition under section 11(6) of the Arbitration and Conciliation Act 1996 for appointment of the sole arbitrator as per the arbitration clause in the agreement dated 2002/2013, Annexure 1 to this petition. So it appears from the records that the notice was issued when the dispute broke out for appointment of the sole arbitrator as per the state arbitration clause, but no response from the opposite party has been received by the petitioner as yet, and hence this application issue notice returnable on 11th of October. No, sorry, 13th of October 2023. Steps for service on the opposite party be taken by the petitioner. The registered posted PD within 3 working days. To take steps within 3 working days.
My lord.
Item number 2.
In person. Yes, in person. You are Mr. Behra.
I'm Mr. Saurabh Savardera.
Yes, yes.
My lord, actually, CMA bill number 313 need to be re-prosecuted. Actually, it is non-appeal dismissed last time. I need one opportunity to re-prosecute the matter. Last time it has been non-appeal and dismissed because of some inconvenience. It has been dismissed.
Who said it? The matter has been dismissed. You are not being audible. We have fixed today.
Yes.
For hear you. Matter has not been dismissed.
No. ARPP 79 has been dismissed. This is CMA bill 313.
We are on ARP 37.
ARBP 37 of 2022.
Your matter
Saurabh
is
Savardera, item number 3.
item number 2. Also see.
CMA bill 313.
You just look at the cause. Just show the cause list.
Item 3.
Item 3, of course, your matter, but
item 2.
You are not the same person.
No. ARPP 37 is not required. Actually, we can withdraw the matter.
You can withdraw the matter.
Yes.
It's your matter.
Yes.
You
ARPP 37 not required.
You filed a memo that I want to withdraw the matter.
Okay. Okay, no problem. Yes.
Just right now you file and passing the order.
Okay.
The petitioner in person, the petitioner has appeared in person and stated that we will not proceed in this petition, and that may be dismissed as not based. So we do not find any impediment, accordingly dismissed as not based. A memorandum is in this regard has been filed by the petitioner. All right.
Item 3 now.
All right.
Item number 3 is to re-prosecute the matters ARPP 79. Last time it has been dismissed because of non-prosecution.
But because you are supposed to remove certain defects, have you removed the defects?
Yes. Defects have been fixed by the ADR, and the purpose is to re-prosecute ARPP 79. Last time it has been dismissed for non-prosecution.
No, that this petition is barred by limitation. You are supposed to file an application for condoning the delay. You have not filed it.
CMA bill 313, it has been fixed by the ADR to re-prosecute the matter.
No, when the matter has been dismissed, you try to just get the assistance from the council.
Steps for limitation not taken until number 3. Number 2,
so you are providing you some more time, file an application under section 5 of the Limitation Act.
Yes.
It is 30 days limitation to filing the application from the date of dismissal.
Kindly provide me some more time.
Yes. Next 15 days give it date. The request to the petition. Let the matter be listed on 29th September 2023. In the meanwhile, the defects is identified by the registry where they are not dated 8/9/20. 23, no, sorry, note there dated 5/9/2023 shall be removed and appropriate steps be taken. So you go, there are two main defects. One defect is in serial number 3 and another defect is serial number 5 small a, and you have not filed the limitation. These are three aspects to take.
Sir, actually it has been fixed by the ADR and told all defects have been removed and it can be listed.
You go to the there. Go
Okay,
registry and
okay.
they will allow you to correct.
Okay,
it.
okay, no problem.
Item number 4. Item 4. ARBP 36 of 2023.
Call up to some time. All right, this bill I am going to dismiss, just remind me, last provision also despite order.
Item number 5. Item number 6.
For appointment of arbitration, my agreement is at annexure 1, and the arbitration clause is at page 13, clause 19 of the agreement. It is a partnership agreement.
Here is 60. Yes,
It is a partnership agreement, and difference between the partner and the arbitration clause is at page 13, clause 19, madam.
clause 19. Why this maintainability petitioner who is appearing?
The opposite party raised a question, as it is not a registered partnership deed, it is not maintainable. So then, different manner, I have already filed a citation of the Honorable Apex Court. That is 2016 Supreme AIR 2016 Supreme Court, page 5359.
Who is appearing for the other side?
Mr. Udgata.
He is not here today. We can take up the matter after some time.
Yes, ma'am.
Item number 7.
Made business. They have for appointment in the arbitration. I think that is proof, madam. Arbitration law is at page 30.
Why the it was dismissed earlier for non-proceeding. Restored.
Mr. Yusuf Panda's name, with consent, I have filed my Bogla Friday, my lord directed to reflect by GK Sir.
That has not been carried out.
Second in the past.
Well, the arbitration clause is as page 30.
Who is, are you appearing for the opposite party?
Madam, yes, madam.
Any objection to the reference?
Madam.
Any objection to reference?
Madam.
Huh? Or it can be referred? Whether it can be referred to arbitration? So you are opposing?
Yes.
Madam.
Have you filed any objection? You have filed the counter affidavit.
He has filed a counter affidavit, my lord. And in the counter, my lord, he has said that the arbitration clause before that it was not there. The agreement between the petitioner and the BSNL in its General Manager Telecom District Berhampur in 2008. It has been extended till 13. In 31st July 14, the agreement annexure 4 was entered into by both the parties for 2 years, wherein the arbitration clause is there. He said in the counter, no, the arbitration clause is effective from the date it has been agreed. The continuation of the between the parties, my lord, starts from 2018 to 31st. It has been admitted in their counter at in paragraph 9 of the counter, my lord. It has been admitted, yes, the agreement entered into 2000 has been extended till 2013 till 31st July 2014. Therefore, my lord,
And the dispute relates to
some bills.
of which time?
Yes, my lord.
Of which time?
11 to 40, 16. 2000,
After the arbitration clause was incorporated.
2011 to 16, yes, my lord. 16 to arbitration clause is 14.
So what is the difficulty? At that time, the arbitration clause was in force.
Yes,
You are already, you argue, then you just reply to him.
but arbitration, first arbitration, my lord, is 29/7/2008 at my lord, annexure 1 at page 12, my lord. The arbitration of the agreement was to give medical facilities to the working employees and
But we are not concerned with this agreement anymore. Are we concerned with this agreement anymore?
no, my lord.
So come straight to the agreement that is concerned and covers the relevant period.
Yes, my lord. Annexure 4, there is arbitration clause at page 30, my lord. May invite my lord's attention to page 30 of the
Annexure 4?
annexure 4 at page 23, but the clause is at page 30. Annexure 4 as page 23. 31st July 2014 to 30th July 2016, that agreement.
It is of 31st
July 2014
to
to 30th July 2016, 2 years, my lord.
already.
And agreement arbitration clause is at page 30, my lord. Clause 15.
Yes.
Clause 15 says, my lord, 15.1. In the event of any question, dispute, or difference arising under this agreement or in connection therewith, except so and so, the same shall be referred to the sole arbitration of the GMTD, General Manager of Telecom Department, District, BSNL, Barampur, or in case his designation is changed or his office is abolished, then in such cases, to the sole arbitration of the officer for the time being entrusted, whether in addition to his own duties or otherwise, with the functions of the GMTD by BSNL, or by whatever designation such an officer may be called, hereinafter referred to as the said whatever designation such an officer may be called, hereinafter referred to as the said officer. And if the GMTD or the said officer is unable or unwilling to act as such, then to sole arbitration of some other persons appointed by the GMTD or the said officer, the agreement.
What is your notice? Comes
Notice 15. Annexure 15 as page 53, my lord. Page 53, annexure 15. This is the notice, and I have suggested 3 names, my lord. My lord, got it. Page 53.
Yes.
Annexure 15, 53, sorry, 53. This is the notice, my lord. And 54, I have named 3 persons, arbiters. Agreement dated so and so executed between BSNL and AMIT hospitals, Amit Hospital, Barampur, for appointment of arbitrator. The subject is, my lord.
All right. Any reply? No.
To this, no reply.
Yes. Now, learned counsel, you make your submission. Please take
Okay.
yes. Yes.
My lord, can we see the prayer person of the petition? Number 11. Yeah. the petitioner therefore fervently prays that this honorable court may graciously be pleased to admit this arbitration petition and issue notices to opposite parties to show cause as to why sole arbitrators shall not be appointed to adjudicate the dispute between the parties to the agreement arising out of it.
These are all right. These are very common. You come to the next part of the prayer.
My lord, one question arises in my mind, my lord. Whether the agreement dated 29/7/2008 as at annexure 1 has been merged with the agreement dated 31st.
Even suppose that is why I have asked him not to read the 2008 agreement.
That has not been merged, my lord.
All right, the bills are of which date? The disputed amount that this was a part of the which bills? Which are the dates of those bills?
They have started from 2011, my lord. At that time, no arbitration clause has been mentioned in
All
the
right,
agreement.
but what is the last transaction?
My
When the last transaction took place?
in
2016,
paragraph 9 of which counter, my lord,
16.
there is not 4.
You read,
Counter affidavit.
yes,
In reply to affirmations made in para 3.3, it is respectively submitted that the agreement dated 29/7/2008.
you are reading from paragraph of your counter affidavit?
Madam,
You are reading from paragraph?
9, madam, of the counter affidavit.
All right.
Page one, page one.
Page number 4.
No, 60, 61. Page 60.
Yes.
Okay.
That is reply to affirmations made in para 3.3, it is respectively submitted that the agreement dated 29/7/2008 was extended by the orders dated so and so. 7/2040 entered upon by the petitioner and the opposite party. The terms and conditions agreement dated to 29/7/2008 continued and default up to 31st/7/2014 only. That is reply to this. In his rejoinder affidavit, paragraph 7, my lord.
Yes.
What they have stated, that in reply to affirmations made in para 3.3, it is respectively submitted that the agreement dated 29/7/2008 was extended by the order dated That's number 2 of the rejoinder affidavit.
Would you kindly come to your annexure D?
Madam,
Annexure D, page 26 of your counter affidavit. Page 26. You are coming also the period for before this new agreement came into existence. How that will be covered by the arbitration clause?
Because my humble submission before my lord is that the agreement dated 29/7/2008, annexure 1, and subsequent extension till the new agreement, it has merged. It is extension of the same terms and conditions, only one in the 31st July.
All right, come to this your agreement again. Let us see
Which matter?
if it is not the agreement. Last agreement, 2014. agreement.
14 years, madam. 2014 agreement is at my lord, page 23 of the arbitration petition, my lord.
Yes.
23, my lord. Annexure 4.
Where is it? From which clause you get support if your submission relating to merger? Show us.
Because my lord, I
Mere continuance is not a merger. It is a separate agreement, it shows.
But my lord, the arbitration clause, which I have read before my lord,
No, if this is a separate agreement without any link with the previous agreement, you cannot bring the arbitration clause in
it is
operation.
my humble submission.
No, sir, sorry, that cannot be done. That cannot be done.
Because my lord, the intention of both the parties.
Where from we are getting the intention, show us. We are
My
ready to
lord,
see. In anywhere, this arbitration clause apply in the earlier agreements also.
No, in only one clause has been changed in the new agreement, my lord, at clause 3, that will give them some discount in the bill, my lord, only that. The hospital, as per norms, should extend medical facilities to BSNL MRS medical reimbursement scheme beneficiaries, taking into account that on indoor admission of working employees only, some percentage as per permissible under BSNL MRS rules of the estimated amount will be sanctioned in advance by BSNL, and remaining amount, if any, of the final bill needs to be paid by employees concerned.
That doesn't relate to the
No,
dispute.
no. It is only this clause has been changed in the newly
No,
agreement.
everything has been changed. It is a completely, just see the indoor treatment will be provided by such and such hospital.
Before it was there, my lord, but the discount part, it has been inserted in the new.
This is a completely an independent contract. How can you say that it is connected or linked with the previous contracts? Or we can read it as merged with the previous contract. There is no such link clause.
Because, my lord, the extension of they have
It is
admitted.
not. Extension can be in various forms. Then we can enter into a new agreement. If there is any problem dispute, it is a separate dispute. They are disconnecting and you are agreeing to coming over to a new agreement.
May I pray, let it come next month, Friday.
You know, how you will improve this case?
No, because I have gone through, I will go through entire clause in the newly.
It will not help you. I am telling you, Mr. Sahu, you are unnecessarily toiling over.
No, my
And
lord.
show him this annexure. This is page 26. They have admit these bills regarding dispute. This agreement covers. We can refer this matter for this dispute. Otherwise, we will not do that.
But because
in-
my
No, you cannot do that. Because you are just reviving those stale matters by you have this clause. That is not permissible in law.
no, because the understanding between the parties has been reflected in this newly
It has
entered.
not been reflected. What you are submitting, there is not a reflection at all in the agreement. And we cannot go beyond the agreement. Because there should be that the other conditions of the agreement will apply. Then we take a decision that it is merged. Other conditions are not made here. The other conditions they are borrowing from their previous agreements. That is not the case here.
The arbitration clause in my lord.
No, sorry, Mr. That way we cannot look into the arbitration clause. Every contract had its own character, own force. That is why I'm asking you if you can show that it is in continuation, even this kind of word is available. We can go back to the other agreement, but there is nothing of that sort.
May I pray next Friday.
No, the adjourning will not improve your case.
Because I have only confined the clause, arbitration clause, my lord, in the new.
No, that they have, you cannot say that because they have already challenged that it is not maintainable. Because the arbitration clause of the whole matters, this arbitration clause doesn't apply. It is their counter affidavit. You cannot say that I am taken by surprise. You cannot also say that. I am referring the matters over the schedule D at page 26 is concerned. This dispute we are referring. Others, it will not be covered by this contract. So we'll pass the order.
Hold on.
Heard Mr. D.K. Sahu 1. And also heard, you are Mr.
Anil Kumar Behra.
Mr. A.C. Behra,
A.K. Behra.
A.K. Behra, and counsel appearing for the opposite party. Have you filed the Wakalatnama?
My lord.
By means of this petition filed under Section 11(6) of the Arbitration and Conciliation Act 1996, the petitioner has asked this court for appointing the arbitrator in terms of the clause 15 of the agreement dated 31/7/2014 annexure 1 to this petition. So, it appears from the notice your notices 7. It appears from the notice dated 4/7. 2018, annexure 15. The petitioner has categorically asked the opposite party to refer the dispute that emerged between them out of the said agreement, out of the agreements to the for arbitration. For adjudication by arbitration. So, according to Mr. Sahu, there had been no response to say that to the said notice. Stop. From the said bill, it clearly appears that the dispute encompasses pending bills for the years 2011, 2012, 2013, 2014, 2015, and 2016. So, but the agreement containing the arbitration clause has been entered into between the parties on 28 July 2008. No. Sorry, just on July 2016, sorry, on 31st July 2014, and the currency of the agreement has been settled by the parties to be 31st July 2014 to 30th July 2016. So Mr. Saul and the council has contended that the said agreement dated 31st July 2014 is the continuation of the agreement dated agreements executed between the parties since 29/7/2008, annexure 1 to the petition. So, Mr. Behra, learned counsel, appearing for the opposite party, has categorically stated that the bills, the disputed bills, which were raised before the 31/7/2014, cannot be brought under the under the arbitration clause, as during those time, admittedly, there had been no arbitration clause in the agreements. So, in this regard, Mr. Behra has drawn the attention of this court to the counter affidavit that has been filed by the opposite party. Stop. In para 5 of the said counter, para 9 of the said counter affidavit, the opposite party has categorically stated as follows, as para 9, that in reply to amendments made in para 3.3, it is respectfully submitted that in the agreement dated 29/7/2008 was extended by the orders dated 28/9/2011, 22/5/2012, 25/8/2012, 19/11/2012, 31/1/2013, 34/2013, and 31/5/2013 under Annexure 2 series of the arbitration petition, close the bracket, for providing medical services keeping all terms and conditions same till the new agreement dated 31/7/2014 entered upon by the petitioner and the opposite party. The terms and conditions of agreement dated 29/7/2008 continued and prevailed up to 31/7/2014 only. 37, stop and quote. With the counter affidavit, the opposite party has made the representation by table of form of the bills those who are pending before 31/7/2014, and those are pending and part of the dispute after 31/7/2014.
Hello, with the due apology, may I interfere? With the due apology, may I interfere? My lord, regarding Annexure D, they have details of the up to 31/7/2014. In the region, we have said this is the first time came to our notice that this period they have given. I may be given liberty to raise the details of the 31st, I mean the Annexure D before the arbitrator. Because before the arbitrator, I may be given liberty because this is first time came to our knowledge. In the region, I have said, if any deviation in the during that period, my lord, I may be given liberty to raise.
All right, that liberty will be given.
That
During
may
the
be given.
period, all material.
That may be given.
Stop. Mr. Behra and counsel is quite empirically stated that the bills shown in the Annexure 1 within the Annexure C to the counter affidavit cannot be brought under the arbitration clause in any manner, even if there is a dispute. But he has fairly admitted that the bills as detailed under Annexure 2, in the Annexure D to the counter affidavit, comes within that period. So even if any other bills are not mentioned in the said Annexure 2, those may be the material if those were raised in terms of the agreement dated 31/7/2014. Stop. We have scrutinized the clause of the agreement dated 31/7/2014. But we find there is no such clause either merging the conditions of the former agreements with the agreement dated 31/7/2014, or there is an independent clause or any clause at all showing that the arbitration clause will have a retrospective operation. Stop. As such, we are unable to accept the submission of Mr. D.K. Saul and a counsel appearing to the petitioner that the arbitration clause will also apply to the earlier agreements which earlier agreements
Started from 29/7.
earlier agreements by way of extension and also to the agreement dated 29th July 2008 annexure 1. So, however, in our considered view, since the dispute relating to the payment of the bill raised by the petitioner after 31/7/2023 are still unresolved, this arbitration petition can be maintained by waiving the objection of the opposite party that the arbitration petition itself is not maintained. So, as such, we appoint, give the list.
3%.
The Upendra Kumar Samal, right, is quite senior. Sri Upendra Kumar Samal, advocate of this High Court, as the arbitrator. So, the arbitration proceeding shall be completed in terms of section 29 shall be completed within the time as prescribed by section 29A of the Arbitration and Conciliation Act 1996. So, but we make it abundantly clear the dispute before 31/7/2014 shall not be deemed to be part of this reference. Stuff. Only those disputes which has arisen after 31/7/2023 shall be part of the reference. Even if any bills are not made part of the annexure 2 to the annexure 2 is annexure D, no?
Annexure D.
Let's see, annexure 2 to the counter affidavit. Those also may be permitted to be raised by the petitioner if those are made incorporated in the statement of claim. Stop. In terms of the above, this the petition stands disposed of. This arbitration proceeding shall be carried on under the aegis of the High Court of Orissa Arbitration Center. Stop. A copy of this order is sent both to the learned coordinator, High Court of Orissa Arbitration Center, and also to the learned the arbitrator. Forthwith.
Item number 8.
Agreement on the case 19. The agreement between the petitioner and the petitioner, the opposite party. For manufacturing of animal feeds used for the company, I mean the petitioner, and the processor is to make the finished product.
Yes,
for the purpose of poultry feed and cattle feed as well as the aqua feed below.
yes.
There is an arbitration clause as page 24, clause number 27. It is expressly agreed between the parties at that disputes. If any arising or in connection with this agreement shall be referred to the sole arbitrator to be appointed by the company under the provision of Arbitration and Conciliation Act 1996, and the venue of such proceedings shall be at Cuttack. In response to that, that dispute arose between the quality as well as the adulteration of the feeds for which the dispute arose, and several correspondence was made by the company, I mean the petitioner. And subsequently, my lord, I have given a notice under annexure.
But the arbitration clause says it is your unilateral power to appoint the arbitrators.
Pardon?
You will come to the arbitration clause again.
Yes.
It shows you have kept the unilateral power of.
No,
appointing
that is there. That is there, my lord. But under the sole arbitrator, under the provisions of arbitration and conciliation, it is that by the company under the provision of Arbitration and Conciliation Act.
What happened to the Supreme Court case?
My lord, on the last occasion also, my lord, I have argued. My friend has raised the question of it is on stamp. That question has been raised by my friend. Earlier, your lordship has that two judgments, SMS is and that Garwell's case, where the Honorable Supreme Court has said the agreement must be registered.
These two judgments he produced on the last occasion.
Must be stamped. But matter has been come to the third judge, that is NN Global Mercantile's case, where it is referred to the larger bench. And the larger bench, my lord, in conclusion.
No, you also stated that your agreement is properly stamped. You
Yes,
show the Jharkhand and
I
other.
have on the last occasion also given that it is properly stamped. Because
No, I will now today hear only on that aspect, what Mr. has to say. And how it is not properly stamped. What is the supporting document?
Your Lordship, on the last occasion, my
let
lord.
me, my lord, for a moment. Take a
Yes.
pause. On the last occasion, I have supplied that government of Jharkhand regarding that revenue registration. Vis-a-vis the government Jharkhand stamp duty in Jharkhand and registration charge. The page again. Another part also. Where the stamp duty, they have given agreement is 3 rupees 50 paisa. So for registration is concerned is 2,000. Subsequently, my lord, it is uploaded in 2023, where the state government, in case of that agreement.
How this document can be reliable document, Mr. Mishra?
Pardon?
This is a part of the essay.
Yes.
How this cannot
No,
be produced before
but
the court.
This is the state
Because
of,
whether this person is properly verified or the checked the proof or not, we do not know.
yes,
You show any gazette notification and other thing, otherwise it cannot be relied.
gazette.
Or any notification, gazette notification, because it is the.
That is gazette. It is on the last page, my lord. They have,
It's in Hindi, my
it is a part of the gazette. Last occasion I have given that gazette.
I am not a very good student of the internet university. That is
No.
the problem.
I am.
It is in Hindi, entire thing.
Uh,
So this, according to you, the registration fee, stamp duty is a 3.50.
Registration is 2,000.
But
But the-
your agreement is not registered agreement.
no,
All right.
my learned friend may develop that the very agreement is an convenience. Your lordship has known that subsection 10 of section 2 of the Stamp Act said the convenience includes a convenience on the sale and every instrument by which property whether movable
No,
or
it
immovable
is
is
not a
transferred.
simple because the agreements
Yes.
provides
Your Lordship,
that any material supplied by the company is unused for packing or other purposes or sold out. These are to reverted to the company back.
yes, Your Lordship.
So you are actually is handling the materials for a definite purpose, and there is a sharing of these profit and other things is there. So it is a solely this agreement. How can you say that it is property is being parted out? There is no questions of reverting the property back to if not utilized during the process.
Your Lordship, why I contend that this is a conveyance, Your Lordship, because if the agreement is looked into as a document, as a whole, Your Lordship,
You read
on the day of entering the agreement, Your Lordship, we are reserving our premises, Your Lordship.
Yes.
We are reserving our manpower for manufacturing their processing, Your Lordship.
Yes.
So had there been a situation where subsequently to the signing of the agreement or entering into the agreement, the contract would have been, the sale would have been dependent on future course of action, then only they would have called it as a mere agreement. Impliedly, admittedly, this is an instrument, Your Lordship, but my learned senior contends it to be an agreement and I contend it to be a conveyance, Your Lordship.
Yes.
For the very reason that on the day I am entering into an agreement, that is 29th May, Your Lordship, I am keeping my premises reserved for them. And they have also...
Let us see the agreement.
Yes, Your Lordship.
Yes.
Page 19 million. Start page 21 from of the years. May permitted to.
So let her show because she
Yes,
is
sir.
raising the objection. You come first to the page 2
Yes, Your Lordship.
and the mid. This agreement witnesses.
Yes, Your Lordship.
Now you are going to, even if it is styled as a weakness, in all purposes, it is not an agreement. It is an instrument of conveyance.
Yes,
That
sir.
is your contention.
Yes, sir.
Show us.
Your
But you
Lordship.
agreed to be nomenclature to be agreement.
Yes, Your Lordship. Your Lordship, third clause, Your Lordship.
Yes.
The company shall deliver or cause to be delivered to the factory of the processor all the raw materials and packing materials as its own cost.
Yes.
However, for any reason where the processor under the instructions number 23, clause 12, Your Lordship. Your Lordship, before that,
Yes.
page 22, clause 10, just before that, Your Lordship, clause 10.
All right.
Clause 10 says the processor agrees to provide the company. Your Lordship, the word is the processor agrees. Agrees to provide the company adequate covered area and go down space subject to a minimum of 15,000 square feet in the existing plant area, excluding office and laboratory for storing raw materials and finished products, Your Lordship. So what my contention is that, Your Lordship, as soon as I have signed the agreement, my part, the part that I was supposed to fulfill, I have started fulfilling that, Your Lordship.
No, that is a subject matter of the dispute whether you have done it properly or not.
Your Lordship, this is what the
Let
agreement
us
says.
first understand how it becomes the instrument of conveyance. Why is the conveyance? Just show us. Always the company is keeping the control over the property that is being supplied to you. As their property, you are only making a process. All right, next come to
Your
the
Lordship,
next page.
what I contend is here, Your Lordship, my space area goes, I have kept it reserved for the company only, Your Lordship. That is what is my contention. So this is a conveyance that is taking place. This is the transmission that is taking place, Your
Yes,
Lordship.
right. It is a sort of a franchisee agreement. Then the temporary position is trusted with you with certain terms and conditions.
Your Lordship, the possession of my
What
company.
does mean by the conveyance? Conveyance means the finally
Yes, sir.
departing with the right over the property.
Yes, sir.
That is there. No, at no point of time they are doing it.
Your Lordship, their part of performance is not yet started yet. But what I'm contending, as soon as I sign this agreement, my part of performance commences, Your Lordship.
Yes.
And also, there is a consideration for the same that has been decided in the agreement itself, Your Lordship. That is clause 12, Your Lordship.
Come to that part.
Clause 12. The company agrees to pay the processor monthly processing charge, all inclusive, subject to deduction of tax as provisions of income tax, the processor in the following manner. Processor shall produce minimum 1000 MT finished products per month and will be paid 1300 MT, including GST and all. Your Lordship, this is the clause that also agrees of the consideration amount, Your Lordship.
This is not a consideration amount, this is the service charge they are giving. to you.
Your Lordship, but the next, that includes the service charge. That is what is my
Yes.
consideration. That includes the service charge.
Yes. That's all, that is the objection.
Your Lordship, I have a judgment of the Honorable Supreme Court, Your Lordship,
Yes.
that is State of Uttaranchal and others versus Khurana Brothers, wherein the question in dispute was, Your Lordship, I may be
Yes.
allowed to provide the copy to.
Uttaranchal versus,
Your Lordship,
what is the citation?
the citation is, Your Lordship, AIR 2011 Supreme Court 224, Your Lordship.
Yes, which paragraph you want?
Your
to-
Lordship, Your Lordship may come to paragraph,
13.
yes, Your Lordship,
13.
paragraph,
Come to
paragraph 13, Your Lordship. Under section 210 of the Stamp Act, Your Lordship. Inter alia, every document by which movable property is transferred is conveyance. Does the Your Lordship, the
No,
question,
Nobody is disputing this idea of conveyance.
yes, Your Lordship.
Whether the movable property is transferred is the issue. They are not being transferred. The ownership of the property is being left with the company.
We cannot totally disintegrate the transfer of the movable property from other aspects that have been involved in the agreement. Why? Because, Your Lordship, taking as a, we have to look into the dominant intention of the agreement, Your Lordship. Your Lordship, they would have provided me the raw materials to process or manufacture the finished product only when I have the amount of area required, and also I have clause 20 also says that I undertake not to divulge or use any of their formulations, Your Lordship. So what I am contending is, Your Lordship, as soon as the agreement was signed, Your Lordship, I have performed my part of the responsibilities. And had it been a matter where the sole transfer of the feed would have been concerned, then it would have been a mere agreement to sale, Your Lordship. But in the present case, the question is not whether there was a mere transfer of the feed itself, Your Lordship. That is not the question. We have to take into
I am
account.
still in doubt whether the transfer is taking place at all by means of this agreement. Whether the transfer is taking place.
Yes, Your Lordship. The transfer has taken place.
How?
The transfer has taken place only when I have assured them that I have given you my company premises, and I hereby undertake not to divulge any of your specifications. I undertake also to accommodate all their manpower, all their supervisors inside my premises, Your Lordship. So that was done as soon as this agreement was entered into. Thereafter, they gave me their raw materials. Also in the agreement, Your Lordship, there is a clause that in case where they are not giving me their raw materials, Your Lordship, I can bring up the same on my own, and I have to only work on their specifications, Your Lordship. So what I am contending, Your Lordship, this is not a case where a product is already ready-made product is there, and the question is involving the transfer of that product from one party to another, Your Lordship. Here we have to take into account the part of services that have to be performed by both the parties, Your Lordship. And as soon as I enter into the agreement, Your Lordship, the opposite party may not have started with their part of
No, the bone of contention is very simple. You say this is not an agreement.
This is in contract for sale.
This is a contract.
Yes,
Or
sir.
whatever. The agreement contract, there is a thin line difference. We will not brood over that.
Yes.
That it is a agreement, and according to you, it is not an agreement. It is an instrument of conveyance.
Yes,
right? If I have correctly understood.
Yes, Your Lordship.
So what is conveyed out?
Your Lordship, conveyed here is the factory premises, The factory
Yes.
premises is conveyed. I have blocked my manpower for them, Your Lordship. I cannot use my manpower for other purposes, Your Lordship.
Yes.
So they have now a right over my factory premises. They have a right over my manpower and the labor charges, Your Lordship. As soon as
So
I have
why
entered
do
into
you
the
style yourself as a processor? If you are parting with your labor force, your factory premises, and not also the process also you are not parting with. So how they have a control over this premises?
we have
No, this is a laying down the specification of your work. If the specification is not followed, because you are yourself is
Your
called-
Lordship,
this is a part of the
I
process.
cannot use my factory premises once I enter into an agreement with them.
No, that is not the, where is that you cannot use your factory
Yes, Your Lordship.
premises? Or you may not use your factory premises for other processes or other thing.
Your
It's a
Lordship,
restriction, it is not conveyance.
Your Lordship, clause 10 says the processor agrees to provide the company adequate covered area and go down space subject to a minimum 15,000 square
Yes,
feet, Your Lordship.
yes.
The processor shall not rent out any portion of the godown in the factory premises above storage space to any other party.
Yes, because the storage clause is under the process, because they are the materials will be stockpiled and they will be processed to the further stage. It is not a conveyance. That if we accept this is a conveyance, every action will be come under the conveyance. You know that the restriction why the Transfer of Property Act has provided, what the
Yes,
transfer has been defined. Very unusual for these common law jurisprudence. That is only in the Transfer of Property Act, we have categorically defined what transfer all about.
Yes, Your Lordship, I agree.
That's why, so we are referring the matter, you will be entitled to raise all the questions there. All right. Mr. T.K. Misral and counsel appearing for the petitioner. Also heard Ms. Dini Mistral and counsel appearing for the opposite parties. This is a petition under section 11(6) of the Arbitration and Conciliation Act for referring the disputes. Where is the notice, your notice?
Notice, my lord, under annexure 21, my lord, that is page 68.
For referring the disputes.
16, page 21.
As
Annexure.
title of in
21.
the notice dated 10 August 2020, annexure 21 series. There is no dispute that in the agreement there is an arbitration clause. At what is this agreement? Just give me a reference.
20,
At
27.
page 24, clause
Clause
27.
27.
The clause 33. No. What is the arbitration clause in the agreement?
27.
There is no dispute between the parties that in the agreement which was entered between the parties on 29th May 2019, there is a agreement clause at para 20 as clause 27, which provides as follows. 27, it is expressly agreed to between the parties that the dispute, if any, arising or in connection with this agreement shall be referred to the sole arbitrator, to be appointed by the company under the provisions of Arbitration and Conciliation Act 1996 and venue of such proceeding shall be at Cuttack. Stop. Mr. Learned Counsel has candidly admitted that even though clause 27 of the said agreement gives the responsibility of referring the dispute to the sole arbitrator to the company, meaning the petitioners, but they have not appointed any arbitrator. Rather, they have given notice to the opposite parties for reference of the dispute to the sole arbitrator. But since this has not been done by the opposite parties, this petition has been filed for reference to the sole arbitrator. Mr. Learned Counsel appearing for the opposite parties has raised two-pronged objection regarding the materiality of this petition. So, first and foremost objection that has been raised is the agreement is not properly stamped, and two, that this agreement, though the instrument has been styled as agreement, but for all purposes, it is an instrument of conveyance. In support of this contention, Mr. Learned Counsel has taken us to three clauses of the agreements. This clause 3A and clause 10 and clause 12. Clause 3A is in respect of the nature of the process that has to be undertaken by the opposite parties. Clause 3A provides the company shall deliver or cause to be delivered to the factory of the processor, the opposite parties, all raw materials and packing materials at its own cost. However, for any reason where the processor, under instruction of the company, uses the raw materials / packing materials, not supplied by the company, the cost thereof shall be borne by the company. Stop. Therefore, it is apparent that the cost of the entire process, materials, and services are borne by the company. Therefore, we apparently do not find any element of parting with the proprietorship of the materials or the finished product. Stop. The clause 10 provides that the processor, the opposite parties, has agreed to provide the company, adequate covered area and downspace subject to a minimum of 15,000 square feet in the existing plant area within first bracket, excluding office and laboratory, close the bracket, for storing raw materials and finished product. Adequate pallets shall be provided by the processor for safekeeping of the raw materials. The processor shall not rent out any portion of the go down in the factory premises above storage space to any other party. Stop. According to Mr. Learned Counsel, that their reading of this clause would show that the space is brought under the control of the company by means of this property agreement. Stop. The clause 12 is regarding the sharing of the payment of the charges. It provides that the company agrees to pay the processor monthly processing charges within the all inclusive, subject to deduction of tax as per provision of the Income Tax Act 1961 to the processor in the following manner, small a within the first bracket. Processor shall produce minimum 1,000 empty finished products per month and will be paid rupees 1,300 per empty in within bracket includes GST, subject to condition that appropriate GST bill is raised by him every month. The company will settle the bill at the earliest stop. If total production is less than 1,000 MT per month due to any reason whatsoever, the charges will be paid proportionately. This court has been persuaded on the basis of the said provision made in the agreement that the instrument is a conveyance, but this court is not satisfied there was any parting or transfer of any materials or the final product. The entire control is with the company and the processor, the opposite parties are paid the charges for processing the product stuff. And the processor doesn't have any sort of control over the property. As such, this court is constrained to observe that the contention raised by Ms. Misra cannot be accepted. Stop. Therefore, we find that the dispute is fit to be referred to arbitration. The result, do you have any preferred name? If you can agree, I can send to the arbitration.
In my notice, my lord, in my notice, I have to put that any other honorable judges of this honorable court.
You want a judge? Okay. Just before that, before getting Mistral, this Miss Mistral and a counsel appearing for the opposite parties has referred a decision of the apex court in state of Uttaranchal and others versus Kurana brothers, reported in year 2011, SC 224, where the apex court has observed that every document by which movable property is transferred is conveyance. Stop. See paragraph. Stop. We have no issue with the said proposition, but it is clear that no takes place in terms of the clauses of the agreement. Stop. We appoint any suggestion from the judges list. I give you the names of the judges who are having the few arbitration cases. Justice R.N. Biswal and BP Das 6 cases, Justice M.M. Das 2 cases, Justice L. Mahapatra 1 case. Home what?
R.N. Biswal.
Huh? R.N. Biswal. R.N. Biswal? All right. Justice R.N. Biswal, a former judge of the High Court, is appointed as the arbitrator. So the arbitration proceeding shall be completed in terms of section 29A of the Arbitration Conciliation Act. The arbitration proceeding being carried on under the aegis of the, they all come to the center or they hold this in their residence also?
No, center.
They come to the center?
Center.
Aegis of the High Court of Orissa, arbitration center. So a copy of this order in terms of the this application stands allowed and disposed of. A copy of this order is served on Justice Biswal, learned arbitrator, and the learned is coordinator on Orissa State such and such. Urgency.
Such a place.
Item 9.
May I please, Lord? Well, I'm requesting for your lordship's permission to appear virtually for the petitioner.
Yes,
The petitioner is an enterprise of the central government. What it essentially does is it carries out civil and construction works for various government entities. Either it does it itself or it contracts it out to contractors and acts as an executing agency. In this case, Millard, the dispute pertains to construction of the National Law University of Odisha, the
Yes.
building of the university. What had actually happened in this matter, Millard, was that I was appointed as the executing agency, and a tender was floated by the respondent, whereby a contractor by the name of NCC Limited was appointed as the contractor. Now, I just very quickly, Millard, want to show to your lordship the arbitration clause in the original agreement and thereafter the amended arbitration clause, because the clause very clearly provides that in case any award is passed in favor of the contractor,
yes,
then the university, which is the respondent, which is the client, will make good my loss and indemnify. Now, please, Millard, for your lordship's consideration, please have the original arbitration clause, which your lordship will find at page 34 of the paper book of the petition.
is it audible to you, Mr. Roth?
Yes.
Yes,
Your lordship has not page 34. Your lordship has not page 34, clause 47.
yes, just a minute. Yes,
Yes, kindly have clause 47 for a minute, Millard. May I read it, Millard, with your lordship's permission?
yes, can read it.
Any dispute arising under this agreement between the parties hereto shall be referred for adjudication to a sole arbitrator in the manner and in terms of provisions as laid down in the GCC. The Chancellor of the NLU Odisha will appoint an arbitrator. Award of the arbitrator shall be final and binding on the parties. Then, Millard, came an amendment to this agreement, and that amendment your lordship finds at page 52. Kindly for a minute, Millard, have page 52.
Page
52, Millard, 52.
Yes,
Yes, Millard, kindly have page 52, the amended clause 47 your lordship finds, which is the third clause in the table. May I read, Millard, with your lordship's permission? Page
you are
50.
referring to 54 or 56.
No, Millard, 52, page 52.
All right. Yes,
Yes, now Millard, amended clause 47 kindly have, which is the third clause in the table.
yes,
The following may be inserted at the end of clause 47, which is that original arbitration clause. The cost of any arbitration award, court decree in favor of contractor will be borne by the client. However, the executing agency shall not charge service charges, that is 5% on such arbitration award, court decree in favor of the contractor. Cost will be determined by so. Now, the university, unfortunately, the construction did not go through at the hands of this particular contractor, which is NCC. NCC took multiple extensions and ultimately could not finish the construction and abandoned the construction. And because of that, Millard, and all this while, Millard, the appointment of the contractor is done by the university. I'm only an agent. The agreement also provides it. All the monitoring of the work is done by the university. Approval of the bills is done by the university. Measurement of the works is done by the university. So university is the principal. I'm only acting as the agent insofar as getting the construction of the university is done. Unfortunately, the contractor does not go through with the construction. He abandons it, and disputes arise originally, my lord, between the petitioner, which is the agent, and the university.
How they
I'm sorry, my lord.
how the university dispute, any dispute with you can emerge with the university?
No, my lord, the contractor said that it's liable for payment of certain amounts, and payments had to be released by the university.
Yes.
So, my lord, the university, the contractor says, I don't recognize you. My arbitration agreement is only and only with you. It's not with the university, which is actually correct. It's not a tripartite agreement. There is one set of agreements between me and the university, which is the agreement and the amended agreement that your lordship just saw.
Yes.
And there is another separate set of agreement between me and the contractor. So the contractor invoked the dispute resolution mechanism in that separate contract between the petitioner and the contractor for unpaid bills, the payments of which had to come from the university. And it ultimately, my lord, secured an award to the tune of 21.75 crores against me. I've obviously separately challenged it, but the clause here, my lord, the amended clause 47 very clearly provides that in case there is any award or there is any court decree in favor of the contractor, then the university will indemnify me. That's the plain language of 47. There can't be any injustice done to the plain language of amended clause 47 that your lordship just saw at page 52. Now, the defense that is sought to be taken, my lord, and it's a very specious and a very misleading one and a complete misinterpretation of clause 47, the amended clause 47. The principal defense that is taken is that reading of clause 47 and the amended clause 47 actually means that in case there is an arbitration between the petitioner and the university, and in the arbitration between the petitioner and the university, an award is passed in favor of the contractor, then the university will indemnify that portion to me. Well, that's completely wholly erroneous for multiple reasons. Number one, in an arbitration between the university and the petitioner, how can an award be passed in favor of the contractor when their own case is that it's not a tripartite agreement? Obviously, the contractor is not a party. How can, in a dispute between A and B, an award be passed in favor of C? That's not possible. And please also see, clause 47 also says in case there is any court decree also.
All right, can you see the agreement first? Come to the agreement.
Yes, Mullah. Now, kindly have, Mullah, the agreement which is entered into between me and the university, which your lordship finds, Mullah, starts at page 27. If your lordship wants to see the relevant clauses, Mullah, I've extracted the relevant clauses also for your lordship's convenience, Mullah, at page 4 onwards of my petition. If your lordship would like to kindly have a look at page 4 of the petition, Mullah, is where all the relevant clauses are extracted of the original agreement.
Just 1 minute, please. So your responsibility under the agreement, only the execution part.
Only the execution, and I was supposed to get 5% service charge for facilitating this entire thing.
Yes.
Over and above the bills of the contractor. So how it used to go was every month the contractor had to submit bills.
Whether
to
that
the
is a
university.
part of, whether that is the part of agreement, except this, the clause 47.
Yes.
Now, whether any part, in any other part, this has been reflected in the agreement.
Yes, but my payment terms are also reflected in this agreement.
Where, just show me.
Yes, but kindly have for a moment. Yes. Please have, my lord, your lordship has page 7, my lord. Page 7 of the petition.
No, I'm on the agreement.
Then, my lord, if your lordship is on the agreement, my lord, kindly have clause number 40.
Yes.
Your lordship has it page 34, my lord, clause 40.
Yes.
The HPL clause 40 says the HPL will submit a monthly work executed bill of the contractor along with their service charges of 5% to NLEO, which will be verified and certified by the PMC. PMC is their committee, their contractor, project management contractor, which is appointed by them, which will be called as RA bills, that is running account bills of the month. Now, the entire contract, Millard, is to the tune of about 79 odd crores for the entire construction that the contractor was supposed to receive from the university. On top of that, I was supposed to levy my 5% service charge, but unfortunately, the contractor, for whatever reasons, could not go through with the construction. The contractor claims, however, that I may have done incomplete work, but I've done 21 crores worth of work, and I am liable to pay that. And he raises a dispute on me saying I am not liable. I don't know. My contract is only with HPL, which is the petitioner before your lordship. I have no agreement whatsoever with the university. So I'm invoking arbitration only against the petitioner. And he ultimately secures an award of 21 crores, which is a payment that the university has to make to them. I am someone, kindly appreciate my difficulty. Today, I am not supposed to make payment to them. Only 5% of the money is to come to me. But the entire construction work today, the payment has today to be borne by me, unfortunately. And even if, that's why I say, even if that clause 47 in the amended agreement was not there, even otherwise, if I've suffered a loss, that's the basic principle of contract law. If I've suffered a loss on account of my principal's fault, that's the entire law on section 230 of the Contract Act, that I've suffered a loss on account of my principal's fault, the agent has to be indemnified. So I today have been saddled with a cost of 21 crores. The amended clause says any award in favor of the contractor will ultimately be borne by the university and university will indemnify me. Their objection is, that no, you are misreading the clause, whereas in fact they are the ones who are misreading the clause. They say that only an award which is passed in favor of the contractor in an arbitration between the university and the petitioner could have been granted to you, which is completely wrong.
Let us see. Sometimes, Mr. Roth, also that how this the award can be made in favor of the contractor.
The lordship sees what's the issue here. There was a contract between the NLEO and the
HPL.
and subsequent thereto, admittedly there was an amendment contract. Both the contracts are placed by my learned friend. But subsequent thereto, but what has happened is the contractor raised some bill against the present petitioner. Now, what is not placed before my lord is the contractor went in an arbitration proceeding before the Delhi High Court arbitration. Now, when the arbitration proceeding was pending, this present petitioner already approached this Honorable Court in arbitration case 39 of 2020, seeking appointment of an arbitrator involving self-same claim.
Okay.
And this Honorable Court, if your lordship kindly turn to page 146, that is what should have been placed. Kindly say 146, madam.
It's
One
already
second,
part
one
of my
second,
petition.
one second, one second, one second. Kindly say 146, madam. This is order dated 12th of February 2021. Passed by this Honorable Court in section 11(6) application filed by the petitioner themselves.
Yes.
May I be permitted to place it? The matter is taken up by video conferencing mode. Mr. M. Balakrishna Rao, granted counsel for the petitioner, seeks leave to withdraw the arbitration petition with liberty to seek appropriate direction in the pending arbitration proceeding between petitioner and OP number 2, that is Mrs. NCC, in accordance with law. ARBP is dismissed as withdrawn with liberty as prayed for. If your lordship sees, the arbitration proceeding was initiated initially, if your lordship see, that is, they had initiated the arbitration proceeding between this petitioner and that NCC milord. Now they wanted to drag this NLEO within that purview of arbitration proceeding. Now they filed an application to implead NLEO as a party there. Now award has been passed, if your lordship see, just page 149. 149 starts, award is from 149. The exact portion of the award where their application to implead NLEO as a party is rejected by the arbitrator, page 156, para 2.13.
Yes.
Are your lordships looking at that? No? Kindly see. An order on respondent's application dated 12th of March 2018 for impleading National Law University as party, response 2 was issued on 18/6, rejecting the application, concluding therein as below. In view of the facts of the matter brought out, I am clearly of the view that neither the respondent have made out a convincing case to implead National Law University Odisha as a party, respondent 2, nor as arbitrator I have authority to do so under the contract in question. The case law cited by the respondent are not considered to bear a ratio with the matter in hand. Accordingly, application is rejected. So, on the face of this order, coupled with the order passed by this Honorable Court, as I have shown to your lordship at 146, they have already challenged the award before the Delhi High Court on section 34. And they have also the liberty to challenge this non-impletion as a ground there before the Delhi High Court. And that proceeding is pending, page 340, kindly see, man. Page 346, I'm so sorry, man. Page 346. So it will amount to a parallel proceeding. Page 346, if your lordship sees, all these facts should have been brought to my lord's notice. Page 346, 5/1/2022. This 34 proceeding is still pending, as my learned friend rightly say. This 34 proceeding is still pending, and they have the liberty of challenging the entire thing, including non-impletion NLU as a party there. So they cannot be allowed to pursue simultaneously two parallel remedies, man.
What is the final order of this part?
Big pardon.
What is the final? It has been decided.
I'm not.
May I clarify? May I clarify?
What is the order ultimately?
Order passed by the
Delhi High Court.
Delhi High Court. Delhi High Court 34 is pending there. That's what is just now said, Lord. 34, that is at 346. 346 at page 355. They have called for the records, provide electronic copies thereof to both parties. Page 355.
Yes.
re-notify on 28th of March 2022. The present stage of that proceeding is for them to appraise, my lords, my lord.
No, they are pending. They are pending.
Yes, they are
Now,
pending.
may I clarify?
Yes, yes.
Now, may I just clarify in 5 minutes? My friend is actually making submissions which favor me. My friend is again and again saying that I should have placed certain things before your lordship and concealing matters. All that he is reading is arising out of my petition. I have disclosed the earlier order of your lordships where I withdrew. I have disclosed that there is a subsequent award. I have disclosed that I filed proceedings before the Delhi High Court. I am not concealing anything. That's point number 1. Point number 2, the order that my friend showed to your lordship, my lord, of February 2021, where I withdrew my first round of petition before your lordships, was because there was no award at that point of time. The invocation was premature, although there is nothing in the order that says so, and a simple withdrawal, unless it decides certain issues, does not bind any parties or does not lay down any exposition of law. All that happened, all that transpired was today there is no award. Proceedings are pending. Whatever remedies you want to take out, you take out in those proceedings. There is no award. Subsequently, the award came to be passed, which is why, in terms of amended clause 47, I now have a fresh cause of action, which is why I came to your lordship. Now, my friend is saying that there can't be 2 parallel proceedings, one in the Delhi High Court, one before your lordship, where I'm seeking appointment of arbitrator. The scope of those 2 proceedings are completely different for the simple reason. What has happened is, in that matter, I am not.
No, there can be any cause for you unless the 34th proceeding
Is final.
Award is final.
Right, my lord. That's
Today
the
there
point.
is, there is an award.
But still, this
I'll
is
tell you
premature.
about it. Yes, no, it's not premature. Today there is an award. That award does
Okay.
not get
Award is under
obliterated.
challenge. We
Yes.
don't know what will
It's
happen
under
to the award.
Just allow me, I'll explain.
Yes.
That award is obviously under challenge, and that's something that I myself disclosed. And I must also go to the extent of further informing your lordship very candidly that the order that my friend showed of the Delhi High Court stays the award also. But the fact of the matter is, even if there is a stay on an order, Chamundi Mopeds from 1993 Supreme Court says the order does not get obliterated.
Right.
The order does not cease to be in operation or cease to be in existence.
Order stands. Order stands. This execution cannot be.
No, my lord, I kindly appreciate, my lord, I'm not on the execution. All that I'm saying is, even if I challenged a proceedings in a 34 before the Delhi High Court, that does not mean the award ceases to be in existence. Award is still in existence. What will happen then? So, my lord, that's the entire principle of Chamundi Mopeds from 1993, that even if there is a stay, even if something is under challenge, even if an order is under challenge, that doesn't mean that order is wiped out. That doesn't mean the order ceases to exist.
Nobody is contending that. Why are you making this submission? I don't understand. Nobody has made this submission. It is a obliterated or wiped out.
All the time,
What Mr. Lotho has stated that it is premature.
Yes.
You are approaching this court.
Tomorrow that award may be set aside. Then we will go through arbitration proceeding, we will impose cost and arbitration payment of fees. Who knows?
I'm so sorry, madam. I'm so sorry, madam. That's an incorrect submission for the simple reason that today proceedings are going on in the Delhi High Court.
Right.
Tomorrow they may even go on in the Supreme Court.
Yes.
What if after 3 years, I have no remedy? Let's say the process goes on before the Delhi High Court and the Supreme Court for more than 3 years, then I don't even have a remedy before your lordship. And the scope of those proceedings is completely different.
If your remedy that is concerned, you have to go to those particular case where the proceeding is stuck up.
Yes.
Not before this court. How can we just start knowing all the facts are on record? We can just refer a matter. What is the purpose of this reference?
Well, the purpose of this reference is very simple, and I'll try and condense my argument. Now, today there is an award. It's not in dispute that there is an award. I've obviously challenged it. As and when what happens to that award, either in the High Court or then in the division bench or then before the Supreme Court, those are the 3 layers of appeal, we don't know. But ultimately, today the position is that in case there is an award in existence, they are liable to indemnify me. Of course, if after the matter is, let's say, decided after 5 years ultimately by the Supreme Court, and the Supreme Court sets it aside, then at that point of time, my lord, it can be said that these proceedings can't continue. Only if the award is set aside, my lord. Today, why am I, my lord, kindly appreciate, why am I before the Delhi High Court? I am not before the Delhi High Court claiming any money. I am rather defending and saying I should not be made to pay money. Here I am approaching your lordship saying I am actually entitled to certain sums of money, which is number one, my lord, the awarded amount. Number two, my 5% service charges. Number three, my lord, my opportunity cost, multiple such things, my lord. I am today asking for amounts, and in the Delhi High Court, my lord, I'm defending the award.
All right, Mr. Gupta, just tell me one thing very categorically that just right at this point of time, what the university has failed to do that which has given you the cause for coming before this court.
Well, two very clear things. Number one, I on the works that have been executed, even if they have been executed in an incomplete manner by the contractor.
There is no question of execution right at this point.
Yes.
There is no question of execution. You yourself have stated before this court, the proceeding under section 34 has been stayed.
Yes.
Your only contention that because of pendency of the 34 proceeding, the award is not wiped out. Nobody is saying that.
That's right.
But this award has cannot be also executed. That is also a legal
No,
fact.
I'm not on execution of the award. I was on
Right.
execution
If there
of
is
the
no
contract.
question of execution, where is your cause?
No,
If there is
I wasn't. I apologize. I didn't mean to say execution of the award. I meant execution of the contract by the contractor. So one grievance is that on the amounts which have been paid or are liable to be paid to the contractor, I am liable to receive 5% commission, which is a cause for me invoking arbitration. Number one. Number two, the amended arbitration clause also says in case there is an arbitration award, which your lordship rightly notes, today, that is not wiped out from existence, they have to indemnify me,
all right, well, that also a contingent affair we are discussing on. When the payment will be made to the contractor, you are entitled to the 5% service charge. Right. Only when the payment will be made to the contractor, then only you are entitled to the 5% service charge. Whether the payment has been made, answer is no.
No, but your lordship is right. No.
So where is the matter? No, I think it is absolutely premature. We are
But
wasting time.
today there is an award. Today there is an award, which is why the
There is an award. Let the award. Your turn will come when the award will be paid to you or to the contractor.
Well, that award.
This is a part of the agreement. Why the court should decide in a reference matter these issues?
Technically, that award, in that sense, if judicial proceedings are to determine,
there is no case of the university has by a letter says that we will not pay you the 5% service charge. There you understand there is a breach in the agreement, and you can come for that dispute in the reference.
But when I
claim the document is available in the docket.
No, but when I claimed the awarded amount, they have refused that. I can show that. Their response to my arbitration invocation, they say that they refuse to pay the awarded amount. I can show that from their response to the invocation, Manoj.
But kindly see the notice.
They have refused.
Already come to your notice of demand.
Kindly see the notice. Where is the 5% is demanded? Kindly see, madam.
Manoj, I am on the award. I clearly mentioned the award, and they refuse to pay the award.
Notice is very important in section 21.
Yes, Manoj, kindly have the notice at page 334.
Right.
I will just show the relevant portion, Manoj.
Yes, at page
334.
334 is where it starts, Manoj.
334.
334 is where it starts, Manoj.
Hmm. 334, I believe it is their reply.
No, but it's my notice. 334 is my notice.
All right.
Page 342. I therefore finally call upon you to pay 21,75,061,796 with
No, before that, two pages before that, two pages before that, Manoj. Internal page 7 of this notice. Kindly see para 17 of this notice. Paragraph 17 of this notice, which is internal page 7. Your lordship has.
Seen, Lord. Kindly.
Page 340.
21 lakhs is the award, 8% the
One moment,
interest,
one moment. sir,
9
please
lakhs
go
paid
back
by
to-
HPCL to the arbitrator towards 50%.
Three forty-four you're referring to,
Page 340,
341.
341.
341.
Subject to my limited knowledge, my lord, I don't find any 5% claim.
No, I'm saying awarded amount.
So
They-
I'm saying I raised a claim on them.
it's only
asking
limited to
them
the award, my lord.
One moment, sir, please. I raised a claim on them, asking them to pay me the awarded amount, and they refused, which is why I've come to your lordship.
Absolutely correct.
Awarded amount is under challenge under section
right.
34 of the proceeding.
Well, it's under challenge, but I can't give up my right to
How can
challenge.
you say that when the, okay, that's all right.
Well, kindly appreciate, Mullah. Today, if that is what my friend is suggesting, that you
He's
keep
not
fighting.
suggesting
I'm not suggesting.
Mr. Gupta, he is not suggesting anything. He says this reference is, the petition for reference is premature.
Premature.
And this award is being examined under section 34 proceeding, and which according to you has been stayed by the Delhi High Court.
Well, let's stay
There is a
also.
standstill. There is a standstill.
No, it's standstill is only for the purposes of execution, Mullah. That's what I'm saying.
That is why.
Yes, Mullah. So, Mullah, the award doesn't get wiped out from existence, Mullah.
So what do you want?
Well, I want appointment of an arbitrator.
This
Mullah.
34 application has been filed by the university.
Beg pardon.
No, Mullah. By
34 filed by them only. They are challenging
by
that.
Mullah.
They are saying to wipe it out.
You are challenging this 30 award.
Mullah, ultimately, may I just say this in one line, Mullah? Ultimately, what will happen is, it can't be that I will ultimately succeed either in 34 or before division bench or Supreme Court. I don't know. I ultimately succeed in getting the award set
No,
aside.
just wait. In one hand, you are challenging the award amount. In other hand, you are saying this award amount has to be paid to by the university.
Yes, Mullah, it has to. Mullah, till the time
No.
award is set aside by a competent court, it stands.
Yes.
I may not be directed to make the payment, but the point is, the clause says in case there is an award. It doesn't say in case the award is satisfied, then I have to pay. All that the clause says is the moment there is an award, they have to indemnify me. Well, what will happen today is this. Well, kindly just appreciate. Well, ultimately, if I succeed in getting the award set aside, either from 34 court or 37 court or Supreme Court, I don't know. I obviously can't make a separate claim at that point of time towards them also. Let's say after 2 years, it's set aside by the 37
So
court.
first of all, what you are saying
Immediately,
now,
Mullah,
there is no award against the university. This is between you and your client.
Yes, Mullah.
There is no university. Client is university. There is no
Well,
award
it's
against the university.
the arrangement is such that the contractor is handpicked by them. His bills are verified by
Sorry,
them.
Mr. Gupta,
Joint
I think
measurements
it's
are
not a
done by
case, we'll just invest more time. Sorry. But Mr.
Well, in my respectful submission, what will ultimately happen is, and I just
Ultimately happen is the subject to the result of the.
No,
because
no,
the
no,
award
no.
is, just wait, the award is not even against the university. The amendments over is concerned, you read it again, it means award has to be understood, it is against the university.
Yes.
Otherwise, this clause will be the meaningless because university cannot come for your contractor.
Well, that's not what that clause says.
Maybe
Kindly again,
and
I have seen it, you read it again. You
yes,
read
but
it
I'll
again.
read it. I'll read it again. The cost of any arbitration award stroke court decree in favor of the contractor will be borne by the client. So,
Yes.
in case the contractor, let's leave aside arbitration, even if they were to invoke some civil proceedings, a civil
Yes.
suit for recovery, even that, in case there is a decree in that civil suit, that also has to be borne by them. So, it can't be, Murad, that the argument that they're raising is that in case there is an award in the proceedings between the university and the petitioner, then I have to pay. Then this clause containing decree would not have been there, Mullah. So, Mullah, that's what I'm saying. What will ultimately happen is, let's say after 2 years, I'm able to somehow get the award set aside. And these proceedings between me and the university are also going on. they automatically get terminated, Malad.
Then
That's
why,
what
why
happens.
to go into the proceeding, wasting money, time, everything?
Because one doesn't know what will happen with the award. Either my friend
Tomorrow
can
you
make
will
a
take,
submission that
tomorrow
he
you will
knows.
take money from me,
No,
and
no,
suppose
I'm
that
sorry.
award is set aside,
Either
then
my
how do I
friend
get
can-
back my money?
One moment, please. Either my friend, I'm
So
also
you will
central
have both
government
the,
enterprise.
you will
I'm
have the
not-
cake and eat it also. Benefit
No,
by both the ways.
I'm not a fly-by-night operator. I'm a central government
Yes,
enterprise.
it is completely.
President of India is the 100% shareholder in my company. I'm not a fly-by-night operator that I'll take his money and run away. So, either my friend should make a statement that he knows the award will be set aside. No one knows the award will be set aside, Madam. After 10 years of litigation up till Supreme Court, if the award is not set aside, where do I stand, Madam? I can't even come back to your lordship because of the 3-year bar of limitation. And that's what I'm saying, Madam. Those are independent proceedings. And ultimately, if the award is set aside, either those proceedings which I'm now seeking to initiate will come to an end, or if the award has already been passed in the proceedings between me and the university, I will refund the amount. That is what will happen. But today I can't be denuded and said that you wait for 10 years, see what happens to your award before 34, 37 in Supreme Court, and then you come to me. It can't happen, Mullah. And my friend today, for him to say that an award which is passed between award which is passed in favor of the contractor in an arbitration between university and the petitioner, how is that possible, Mullah? Is it ever possible, permissible, where an arbitrator is a creature of the statute, that proceedings are going on between university and HPL and award is passed in favor of the contractor? Is it possible, Mullah?
Already.
Where a contractor is not even a party?
Yes.
So not completely erroneous interpretation. All that the clause says is the moment there is an award, they have to indemnify. That's the long and short.
Yes. Yes, Mr. Roth, anything more?
Lord, there is a, in legal parlance, one called it res sub judice. Res sub judice, meaning thereby, once an appeal is filed against a judgment, the finality stands destroyed. There are 2 Supreme Court judgments. If your lordship permits, I can place it later on. But let us not go to that issue, Lord. But keeping all this aspect in view, 34.
This will not apply. This doctrine will not apply.
No.
Yes,
Because
it's an
it's
11th limited inquiry.
Right.
Yes,
Keeping
why
that
you
aside,
understand
keeping
that
that aside.
in a reference, you do not decide.
Right,
the
Lord, keeping that
issues of
aside,
the
keeping that aside, my lord. 34 is admittedly pending. So, and my interview, they wanted to implicate me as a party in that proceeding, that has been admittedly rejected. So all these questions, NLU be a party there, or it will be liability of NLU, are all sub judice there in 34.
No, wrong.
34, the NLU is not a party.
No,
No.
before the arbitrator, they wanted me to be a party. They filed an application. I have pointed out that order before your lordship, my lord. That application has been rejected. Kindly see that award. In that award itself, page 155. Kindly see.
No, this is not in dispute.
But now question is, they filed an application to implicate us as a party before the arbitrator. Now the learned arbitrator, while passing an award in favor of that other party, page 156, rejected their application, rejected this petitioner's application to implicate NLU as a party there in that arbitration proceeding.
Hence, we are before your lordships.
Kindly see, my lord. That is order dated 12th of March, 18th of June 2018. That operative part of the order is reproduced in the award itself. So they have lost to implicate NLU as a party in the arbitration proceeding, referring to clause 47 itself.
Well, please have page 187.
Then they have filed 34. So in 34, while challenging the award, it is also open for them to challenge this part of the award also.
Well, my friend is wrong. Please have page 187 of the award. Please have page 187. He's completely wrong.
All right.
Great.
Well, just for a moment, please have page 187. Well, just one final point.
What is the final point?
Well, the final point is my friend is saying that I filed an application to implead the university to the arbitration that was rejected. Against that, I even went to the Delhi High Court, Mulad. That was also rejected, saying that those are different contracts, Mulad. And they can't be clubbed, which is why I'm before your lordship.
Exactly. That is rightly done.
Hence,
And
we
Mulad,
are before your
if it's
lordship.
been rejected, Mulad, then
That's
I'm
right.
remediless, Mulad.
That's
Mulad,
all.
if I
That is
can't-
your final point. Okay.
Mulad, if I can't implement them, if those are separate contracts, then I
All
can't.
right. All right. All right. These are not, their
Definitely.
impleachment, I think, was not required at all, according to my understanding of the facts. All right. Mr. Gaurav Gupta, learned counsel appealing for the petitioner. Also heard Mr. P.K. Roth and his senior counsel, assisted
Mr. Saib Roth, S. Roth.
by Mr. S. Roth, learned counsel for the respondent, opposite party. Stop. This is an application under section 11(6) of the Arbitration and Conciliation Act, urging this court to refer the dispute as according to the petitioner exists between the petitioner and the respondent to the arbitrator for adjudication. There is no dispute so far the factual matrix is concerned. The opposite party floated a tender for construction of buildings in the university premises, and the petitioner was the successful bidder and was awarded the contract work under the terms and conditions as settled by the agreement. The petitioner engaged one contractor to execute the same work for his behalf unto to the satisfaction of the client from the opposite party. At some point, some dispute arose between the contractor and the petitioner, and the matter was referred to the contractor, and matter was referred to the arbitration. And on the culmination of the arbitration proceeding, the award was passed by the said arbitrator, and admittedly that has been challenged by the present petitioner under section 34 of the Arbitration and Conciliation Act. And the said proceeding is still inconclusive. During that time, another application has been filed before the Delhi High Court for staying the proceeding under section 34 of the Arbitration and Conciliation in 1996. It is the admitted position that the Delhi High Court has stayed the said proceeding. So, the proceeding is now in that stage. Stop. During pendency of the said proceedings, the petitioner herein served a notice on the opposite parties by invoking the clause 47 with its amendment clause demanding that a sum of rupees 21 crore 75 lakhs 61,706 and interest at the rate of 8% on the aforesaid sum from 5/10/2021 till the date of actual payment, along with rupees 15 lakhs paid by the petitioner to the arbitrators and advocates, together with 55,000 being the cost of the notice to the HPL within 10 days from the date of receipt of the notice. So, it has been also stated that the said dispute be referred to the sole arbitrator as per the arbitration clause, failing which the petitioner shall be at liberty to take appropriate course available at law. So, since the demand has not been fulfilled by the university authority, by the opposite party, this petition has been filed for reference to the arbitrator. Stop. For purpose of our reference, we may look at the award dated 6/9/2021, passed in the arbitration proceeding between Messrs. NCC Limited and the petitioner. The said arbitral award has inter alia reflected an order on the petitioner's application dated 12/3/2018 for impleading National Law University, Orissa as a party, as respondent number 2 was stopped. The said application was disposed of by the order dated 18/6/2018, rejecting the application of impleadment. So while rejecting, the following observation has been made. Quote, in view of the facts and matters brought out, I am clearly of the view that neither the respondent have made out a convincing case to implead National Law University Orissa as a party respondent number 2, nor an arbitrator. So I have the authority to do so under the contract in question. The one the case laws cited by the respondent the petitioner hearing are not considered to bear any ratio with the matter in hand. Accordingly, the application is rejected. After that, the word in favor of the contractor was framed in the following manner, quote. In consideration of all the claims of the claimant and the counterclaims of respondents, I hereby give an award in favor of the claimant amounting to rupees 21,75,61,796 in word, to be paid by the respondent. Future interest is also allowed on the award amount at 8% per annum, simple, which will start accruing from 1 month and after the date of award. In addition, I make a declaratory award against claim number 1B of the claimant that performance bank guarantee number 130391 1B capital B capital G 000077 dated 31/1/2011 be released by the respondents to the claimant parties. The claimant party shall bear the cost and quote. This is the basis of the raising the demand against the opposite party. On the basis of, as stated by Mr. Gupta Learned Counsel, appearing for the petitioner, on the basis of the amended arbitration clause, which has been inserted by the subsequent supplementary agreement dated added to the agreement, supplementary, as the supplementary agreement, annexure. It is 12, I think, annexure 12. Just find out. Supplementary agreement dated 3rd February 2012. For purpose of reference, the amended added part of clause 47 is quoted below. Quote, the cost of any arbitration award court decree in favor of contractor will be borne by the client. However, the executive agency shall not charge service charges, i.e. 5% on such arbitration award / court decree in favor of the contractor. Stop. On the basis of that provision, Mr. Gupta Learned Counsel has strenuously argued before this court that since the award has not been wiped out because of the stay order, the university authority is under obligation to make payment of the arbitral awards and also the costs as provided therein with service charges 5% on such arbitration award. irrespective, without taking into consideration the fact that the said award has been challenged by the petitioner himself in a proceeding under section 34 of the Arbitration and Conciliation Act. There cannot be any amount of doubt about the legal position in respect of the award when it is stayed. If any stay order is passed on the operation of the award, in the legal parlance, it can be stated that award has been suspended, has been kept in animated suspension. So, meaning the award stands still there, and its fate will be depending on the proceedings under which its legality will be decided. Mr. P.K. Roth, Mr. Roth, learned counsel appearing for the petitioner, has drawn our attention to the notice of demand is referred, only to point out that there is no demand for payment of the 5% service charge. As such relief is hit by Section 21 of the Arbitration and Conciliation Act 1996. Stop. This court is really surprised when the petitioner has challenged the legality of the arbitral award. How can he raise the demand to the opposite parties for payment? Stop. Unless the award is settled by the judicial scrutiny under Section 34 and 37, if any aggrieved person prefers an appeal, the award doesn't get its final appeal. So the pendency of the proceeding under Section 34 of the Arbitration and Conciliation Act is still inconclusive, even though it's stopped. And as noted already, the proceeding has been stayed by an order of Delhi High Court. Stop. In our consideration, having taken off all the bundle of facts, in my consideration, having taken the bundle of facts is displayed in this petition is entirely unsustainable for absence of cause, as the university authority is not expected to pay satisfy the demand when the award is under challenge. Stop. Before parting with the records, Mr. Gupta, learned counsel, has raised a question whether the petitioner will be waiting for the fruits of the award in final. In the circumstances of the case, I would only observe it is up to the petitioner whether he will abandon his challenge and come for invoking the clause 47 of the agreement. Accordingly, this petition stands dismissed.
Item number 10.
I'm grateful.
Yes.
May I please, my lords? My lords, kindly turn to page 35.
How much time will take, Mr. Behura?
My lords, 5 minutes my side. But there is a question of limitation
My
that I have
objection
to
will take
overcome.
around 10 minutes. 10 minutes. Pardon.
Any next week, your lordship, you tired next week, your lordship.
Better, huh? Let's take it straight. 15th, no? List on 15th of September 2023.
My lords are putting it on 15th, your lordship.
15th.
Lordship. My only objection is on the point of limitation.
And that is what, it will take some time.
Yes, your lordship, your lordship would need to refer to a few.
UC Behral and counsel for the petitioner and Mr. S.S. Mohanty for the response part.
Grateful, your lordship.
Item 11.
Item 11, my lord, 2 days before I have collected the counter, I will pray for your lordship to file rejoinder 2 weeks time.
2 weeks time.
2 weeks time.
List on 22. You are Mr. Bhushan.
R.K. Satpathy, my lord.
At the request of Mr. R.K. Satpathy and counsel appearing for the petitioner. In the meanwhile, the petitioner shall invariably file the rejoinder. Who is appearing to the opposite party?
My lord.
Mr. Kashyap, you are okay now? Mr. S.S. Kashyap, one of CBC appears for the opposite party.
Item 12.
I beg to appear on the virtual mode.
Yes.
There's an application filed by the present petitioner who was a contractor, electrical contractor, executed certain works, and these bills were not paid, and she has issued a notice.
Is appearing to the opposite party.
I am appearing for opposite party number 1 and 2, my lord. I have filed my counter. Last occasion, the petitioner took time to file rejoinder.
I have already filed the rejoinder. Madam.
No, it has not. You have not served copy on me.
I have sent it to the same address, mail address. Which you have.
I have not received. That is why. Can you please send once again? The voting also shows no rejoinder has been filed.
The same address from through which I received your counter also.
All right, I'll check up, my lord. You'll also may kindly take up next week in that event. The noting also shows that rejoinder has not been filed.
Your rejoinder is also not tagged with the records, so we are fixing on the next Friday. In the meanwhile, you ensure that your rejoinder has been properly uploaded.
Sure.
We are also directing the registry to check up.
The report says that actually it has already been.
No, Mr. Murthy, you are absolutely right. Because we are experimenting with the technology, there is a lot of gaps. We are trying to just address those gaps.
Yes, yes.
Mr. T.N. Murthy and counsel appearing for the petitioner has submitted that the petition has already uploaded the rejoinder. But Mr. Mistral and counsel appearing for the opposite party number 1 and 2.
Yes.
Has stated that he has not received a copy of the rejoinder. Stop. I would request Mr. Murthy and counsel to supply a copy of the rejoinder to Mr. Mishra within 3 days from today in his email. Share the email number. You have the email number of Mr. Mishra?
Yeah, I have received the counter through email.
Sent by email. Stop. List is directed to verify whether the rejoinder has been uploaded. If uploaded, a downloaded copy be made part of the physical records, and the scanned copy to be part of the digital record. Next.
Obliged.
15. List on 15.
Item 13.
13 mallards. I am appealing for the petitioners, mallards, from 13 to 18 mallards. They are supposed to file the counter, mallards. Last mallards.
That's what I am 14. Item 13, 14, 16 and 17. Today I am filing the counter on behalf of the statement.
State.
All right. Mr. P.K. Mudali, additional government advocate appearing for the state, has stated that opposite party number 1 has stated that in the course of the day, the opposite party number 1 will file the counter.
Counter affidavit on behalf of opposite partner 4.
Who? You're appearing for 4?
No, I am appearing for the opposite. The counter affidavit today I am filing on behalf of opposite partner 4.
Okay, opposite party number 4. You are appearing the last occasion for 1, I think, government, state.
Yes, madam. 1, 3, 4 and
All right.
All are
5
state
madam.
authority.
All right, 4
All
is
the state.
Yes, yes.
All right. So I can write all the names, that it will complete actually.
For 2, I am there.
1, 3, 4 and 5.
5 madam.
Stop. The counter affidavit, stop. 1, 2, 4, 5. The 4 is filing, 4 is the principal opposite party, no?
4 is the executing authority.
That is why. Mr. P.K. Roth, Senior Counsel, estate by Mr. Behra is not there.
Yes, Rath.
Yes, Counsel for the opposite party number 2. Let the matter be listed on 22nd of
May I just
September 2023.
may I just pray,
May I
madam?
pray for some more time madam, because I've gone through a surgery, my lords. I'm recovering from a surgery. Can it be taken up last week, my lords? Or first week of
29th of September.
my lords? Oh, highly obliged, my lords.
29.
In the meanwhile, the petitioner will be at liberty to file the result.
Same order in item 14, 16 and 17.
This 13, it is 13, 14, 16 and 17, all 15 only.
On behalf of respondent number 2, Lord, they are also filing counter today with a copy to my learned friend. With that.
Only. Just before that, as a paper and stated that the opposite party number 2 has also filed the counter affidavit today.
And so far as item 15 is concerned, I played 2 weeks time to file count.
That is all.
Yes,
That is all. Yes, 29th.
All right. Mr. P.K. Madhuli, Council. Appearing for such parties.
To 17. From 13 to 17, this process plot filing is over, my lord. Now 18 is a matter where it's a part of a batch matter. Let's be pleased to fix all those matters to 15. Kindly see those.
For some accommodation despite our order dated 1/9/2023, where we have despite my order, despite the order dated 1/9/2023. However, since in the analogous matter, Mr. Moguli has filed 4 counter affidavits. We considered this prayer deserves to be considered leniently accordingly. Let the matter be listed and has let the matter be listed on 29 2023. In the meanwhile, in 13 also you have, in 15 you have
15 million. 15.
filed.
No, 15.
The opposite party members shall invariably file the counter affidavit, as this court will not make any further accommodation for the same purpose. Mr. P.K. Roth, the same affidavit is being filed. And what about the 17?
Item 18.
Up to 17, the same order. Same order up to 17. Item 18, I have handed over orders to my lords, my lord. Those orders pertaining to batch of cases where this item 18 is also a part of the same batch. Let's to fix those matters on 15.
My lords are already fixed the matters on 15. What I pray, my lords, since I'm recovering from a surgery, I've been advised 20 days rest. So all these matters may be also placed on 29th, my lords. Or maybe on first week of
29th.
29. I don't have any problem for 29, but lots of matter will come. So it may create confusion in batch of cases.
Or maybe first week of October, my lords, first week. Because
let it be on 29. Let's see what happens.
Yes, my lords, 29. My lords, 29.
This item numbers
18.
18 only.
18. So the matters fixed on 15 also will go to 29. Mr. Parida.
My lords, I'm recovering from surgery, my lords. Just day refused to
But these matters, unless it will come on 15.
Yes, my lord. This item 18 was supposed to come on 15. Because it's a part of a batch matter, 6 or 7 matters.
Let it come on 18th. We'll pass the adjournment order because otherwise it will, the computer will be a little bit confused.
My lord, as your lordship please, my lord, it will come on 18, man. 15.
15th first, let the matter come.
Let it appear on 15, man.
Miles. As my lordship, please.
Great.
Over.
Deeply obligements.
Just a minute.
My lords,
This order also just 1 line, this next item. Let the matter be listed on 15. This is today's matter, this item 18, not on 15. But this is the part, where is Mr. Roth?
My lord,
This is the part of
my lord, the batch matter is fixed to 15th.
connecting to the 18.
All right, let the matter
Miles.
be listed. Just give this bunch, just give the bunch. Along with the petition number sequence, there's a 4 or 5 cases are there. You just insert this number and. Along with the petition number 27 and 25. All right. You have filed the counter affidavit?
My lord, file. In item number 18, it is filed, man.
All right. Do you like to file any rejoinder?
My lords, I'd like to file a rejoinder. That's why it's praying for time, but on 15th, my lords, I think I will need time, my lords.
All right.
I have not yet recovered.
The petitioner may file the rejoinder if anything. Okay.
Deeply obliged, my lords.
Last tour matter item number 4. Item number 5.
The same order, it will be there. Despite the order dated 1/9/2023, none appears for the petition. So in the order dated 1/9/2023, it was clearly observed for that. Clearly observed as follows, just subpara. It is absolutely made clear that if the defects are not removed by the next day, and on that date, there is no representation from the petitioner, this court will be compelled to pass order for non-prosecution. This petition, as this petition stands, dismissed for non-prosecution. Same order in the next case.
Item 6. I'm sorry, my lord, I was not present when the matter was called in the morning.
So we'll take up on 15th then. Yes, today there is no time. Mr. K. Guru and counsel appears for the petitioner. On the petitioner and on the second call, Mr. Sanjeev Udgadal and counsel appears for the opposite party. Let the matter be listed on 15/9/2020. 50 September.
Okay. Can I have your lordship's indulgence, my lord, to make a mention, my lord? I am constrained to make this mention because the writ appeal. Now it
is making a mention on Monday. It is a division bench matter.
The difficulty is this, the EPF has given a notice of course of action. Today is the last date, 2 days or holidays. Unless it's taken up on 11th, it's a state university. EPF is not applicable.
It will be all right. Just take up the matter. You mentioned the matter before the register judicial. Tell that I have requested.
My lord.
I'll get.
My lord, kindly take a glass to the last order. I have complied that order and I have served the copy of the same PL along.
I have appeared in this matter for Lord Jagannath. My senior short copy.
Restoration matter.
Yes.
My lord, it is a 8/1/2016, my lord. So you want to restore the writ petition of 2016. Writ petition of 2006. It was dismissed on 8/1/2016, my lord. There is delay of near about 4 years, my lord. And so far, my lord, merit is concerned, my lord. Now it is covered by the judgment of Honorable Supreme Court Siddhamata case, my lord. So property status is, my lord, Amrutamani and belongs to Lord Jagannath. And it was under the Marfadar pe Motho. So as per the judgment of Honorable Apex Court, my lord, Motho is mere a manager and it cannot transfer, my lord. And it is automatic, my lord. Section 5 of the Temple Act, it came into force 1954. Section 5 says all the endowment of Lord is now vested to Temple Managing Committee. So by virtue of that, my lord, on merit also is not case, my lord. And the OEA authority recorded the property in favor of Lord Jagannath, and the appellate also confirmed the order. And it is also lost, my lord. It is 2016, my lord, it is dismissed. Now after 4 years, my lord, the property belongs to Lord Jagannath.
If the Supreme Court decision covers the controversy, what
Yes,
should
not
go for? Even if we allow your petition and also dismiss your petition today itself.
My lord, the fact is like this.
We have the copy of the
My
Supreme
lord, relying upon the judgment of the Supreme Court, my lord, our High Court has seen a lot of judgments, my lord. My lord Justice Sahu also a party to the judgment, lord. I have so many judgments I am having, my lord. Paper book I have made.
Copy of that maybe
relating to OEA matter itself. Lord, last page you will see. And thereafter also, my lord Justice S.K. Mishra has given the judgment, my lord. Sitting with Dr. A.K. Mishra.
So, Mr. Tripathi, even if we restore your petition, we dismiss your petition.
No, my lord, kindly take a glance to the merit of the case.
What is the merit? He says that it is the entire issue has been settled by the Supreme Court. What further merit we have right to look into?
So that matter was not covered by that case, my lord. I have to go through it.
So many judgments, my lord. There are so many cases I am having.
You argue on merit first.
Yes, ma'am.
Because such a long delay, if you find there is no
Yes,
merit
yes.
in your case, on that ground also you can dismiss the invitation petition. Yes.
Yes, my lord. The disputed properties was recorded in the name of a motto, that is Khaki Akhada motto, and the status of the land was Amrutamani. In the year 1950, kindly take a glance to page 7 of my writ application, page 7. On 25/150, the Mahanta of that motto had executed a registered permanent lease deed.
Yes.
Yeah, in favor of the father of the petitioner and inducted as tenant by accepting the salami. A registered by virtue of that registered permanent lease deed, the father of the petitioner continued to possess it, and in the year 1967, this property was declared as the trust estate, property of the trust estate. That is,
Please come to the order, we passed in that writ petition. That is
my lord,
14709, 2006.
my lord, order dated, my lord. The last order was passed on 8/1.
8/1/2016.
Yes, my lord. I filed that postal requisite shall be filed within a week, failing which the writ petition shall stand dismissed without further reference to the bench.
You did not comply that order for which it was.
That was for this reason it was dismissed.
Right, so it was on 18/2/2016.
Yes.
Then you have filed this CMAPL in the year 2019.
412. 412.
412. And the delay has been pointed out to be how many years?
100, 1,400 days.
3 years.
1400.
Roughly around 4 years.
More than 3 years, right?
More than 3 years. That is why so far as the delay is concerned, I am relying on the judgment of.
So like you are going to merit on that.
Yes, madam. By virtue of the registered performance deed, the father of the petitioner continued to possess the disputed land, and during the year 1967, on 21/12/1967, the reference was made by the collector and the tribunal judge.
Your prayer is to, in the main writ petition, your prayer is to pass 2 annexures.
Yes.
One is annexure 11 and the other is annexure 13.
Yes, my lord, we met. It was also, this matter was agitated in the in a reported decision reported in volume 40, 1974 CLT, page 41. This matter was also once upon a time, it was before this honorable court, and the honorable court quashed the order of the commissioner. And yes.
See that.
So far as the chronological.
Annexure 11 is the order passed by the Tahsildar Puri in OEA claim case number 218 of 1990. Please come to that main writ petition. Page number is 66.
Yes, my lord.
So that is the order dated 8/11/2000.
It was challenged. Challenged in the appeal, thereafter in the writ application.
Just come to the operative part of the order of that annexure 11. You come to this page number 6 of that order.
Yes.
That is running page 71.
Yes, my lord. In view of the above facts.
Right.
In view of the above facts, coupled with the instructions contained in Revenue and Excise Department, Odisha Bhubaneswar letter number 17920 dated 3/4/92, and the Board of Revenue Odisha Kotak letter number 16935 oblique LRS dated 26/12/92. The suit land noted below is settled in favor of Sri Jagannath Mahaprabhu Vijay Puri, Marfadar Managing Committee, Sri Jagannath Temple Puri, subject to realization of the back rent with effect from 18/3/74. That is the date of vesting of the estate and Lord Jagannath, realization of the salami from the administrator Sri Jagannath Temple Puri has been exempted.
So these various plots are there.
Yes, my
Which
lord.
plot belong to this present petition?
My plot is, my lord.
It's not that entire plots are used. So it under Khata number 75, there are various plots. Which particular plot relates to you?
This is reflected in annexure 1, my lord.
You have to say which one of this influence order you are showing us, that is annexure page number 7 of annexure 11. Which is that particular plot? Which relates to the Sankarlal Patwari.
This is the hall plot. It is to be correlated, my lord, because so far as the annexure 1 is concerned, in the year 1950.
Unless you say that, how can we know it? How can the rate will be maintainable? Unless you say that this particular plot, by virtue of this particular order, my plot, I am affected, and this plot, particular plot is related to me. This is the Sabik one and this is the Hal one.
So that you have not stated in your writ petition.
The entire land has been reflected in the Annexure 1, my lord. In Annexure 1, entire land was leased out to me.
Are you the owner of all these lands, or are you interested in all those plots?
My lord,
Because
can kindly
suppose the owners of those plots have not come to this court. You are only aggrieved by one particular plot. So you should point out which plot belongs to you.
the entire land was leased out to me.
This Khata number 75.
Khata number 75.
Under Khata number 75, there are about
59.
huh?
59
56 plots. 56 plots. Next page.
Total 1 acres, 600.
11 acre.
So your case is that this entire 56 plots, which is of the area acre, 11 acre and 770, entire plot was leased to you.
Annexure 1 says like this, my lord.
Then what happened in the annexure 13 is the order.
Annexure 13, my lord. In Annexure
You are
13.
also challenging annexure 13.
Yes, Annexure 13 is the appeal.
Yes.
The appellate court confirmed the order of the Tahsildar. My lord,
Come to
civil.
the last portion of the appellate court order, page number 5. Page 82 is the running page.
As per the Sabikarwar,
No. You come to the last portion, the last paragraph. The land has been leased out.
the land has been leased out in the year 1950 without prior permission of the Endowment Commissioner as required under Section 19 of the OHRE Act. The absence of permission under Section 19 of OHRE Act, sanction of the lease is illegal and void. The purpose of lease for repair of motor building is also not tenable in the eye of law. Lord Jagannath Mahaprabhu is the privileged royalty under the provisions of Section 224 of the OLR Act. Hence, no right of tenancy can be accrued. Moreover, the land is within the municipal area of Puri town and the lease for construction of dwelling house. Hence, right of occupancy cannot also be accrued. My lord, so far as OHRE Act is concerned, it came to force in the year 1951. My lease is of the, prior to that.
Your lease is of the year 1950.
50. So, in the earlier decision reported in
Prior to this 1951 Act.
Yes.
Which was that act which was governing the field?
That was the old act of the year 1939.
This lease procedure must have been.
Yes, that
procedure has been followed.
That procedure was not followed. Then that is why the honorable court in volume 40, 1974 CLT, page 41. I'm just giving this.
No, you let us say accept your contention that this OHRE Act came into force in 1951 and this particular lease which has been in your favor, that is of the year 1950. So the question of application of Section 19 is not there.
Is not.
You yourself says that prior to that there is another act and there also how it is to be leased out, that procedure was being laid down and that procedure even has not been followed.
Yes.
Then how you are entitled to say that that lease was perfect?
My lord, kindly take a glance to that judgment.
The matter was that
this property belonged to a motha, not the Srimandira of Puri. It was a property as motha. The issue was that whether the property, Lord Jagannath was the presiding deity of that motha. The issue is that whether the property of motha was the property of Lord Jagannath or the property of motha. The status was, as because the status of the land was Amruta Munai, the issue was raised that as because it is the Amruta Munai land, so land belong to
Lord Jagannath.
Belong to Lord Jagannath. That matter was agitated there in that decision. The Commissioner of Endowment had passed order for eviction of the father of the petitioner. That was quashed by this honorable court, saying that the commissioner is to first take a decision whether this act is applicable or not, and whether another issue is also there regarding adverse possession. That was also agitated in that reported decision, and the honorable court said that that matter can be agitated before the commissioner, and commissioner is to take a decision.
Brilliant. What about this particular line which has been, is harping on that the lease is of the year 1950.
Your Lordship, before that, you also may kindly turn to page 81 of that appellate court order. 81. Internal page 4. Issue is there.
Yes.
81.
Yes.
Last para, my lord.
Gone through the case.
Yes. Gone through the case record and the arguments advanced by both the learned counsel. For the foregoing discussions, it is to be determined whether the suit property belongs to Lord Jagannath Mahaprabhu Vijay Puri Marpat Managing Committee or to the Mahanta Khaki Akhada Matha, whether the present appellant has acquired right, title and interest in respect of the case land. As per Sabi Karwa, the land was recorded in the name of Lord Jagannath Mahaprabhu Vijay Marpat Mahanta Khaki Akhada Matha Puri with Amrutamani status. This is very important, my lord. Amrutamani status, my lord, the Marpat is gone, my lord. As per the judgment of the Honorable Appellate Court, Marpat, your lordship knows, my lord, is a mere manager, my lord. He cannot claim any right over the property. And estate vested to state government on 18,374, my lord. This 18,374 notification where the state, it was vested to state government, it was challenged in Supreme Court. Thereafter, it is turned down in this judgment, my lord, Siddhamata judgment. So after vesting, the ex-intermediary Mahanta Khaki Akhada Matha has not filed any claim under section 6(7) of the OEA Act, nor any Jamabandi in favor of the tenants. The Jagannath Temple Act 1954 came into force in the year 1955. As per section 5 of the said act, the properties endowed to Lord Jagannath belongs to the property of Lord Jagannath Mahaprabhu Vijay Marpat Managing Committee. So here, my lord, section 5 is as independent identity. It also given by the Honorable Supreme Court in the judgment rendered by in the Siddhamata judgment. Section 60, section 5 it is under a statute, my lord. It is automatic. Even in the property of Lord Jagannath, no case to be filed. It is to be flow automatically to the temple managing committee. Because initially it was not there as per section 200. Subsequently, it was redundant by the Honorable Supreme Court. And now it says, my lord, language of the Supreme Court is like this, my lord. I may be permitted to read one paragraph from the judgment, my lord. At the cost of repetition, we reproduce the relevant part of section 200 of the OEA Act 1951 as under.
Which paragraph you are reading?
My lord, it may not be your lordship's. It is paragraph, my lord, it's page 47, internal page 40, running page 47. It is paragraph 23.
This
Paragraph 23 starts from in the instant case, my lord.
Yes.
My lord got it in the instant case.
Yes.
There is a clear conflict between the provisions of section 20 of the OEA Act 1951, section 5 and 30 of the Temple Act 1955. It is also clear that both the above statutory provisions of the acts cannot survive together. While the rule of the harmonious construction must be given effect to as far as possible when the provisions of two statutes are irreconcilable. it needs to be decided as to which provision must be given effect to. In the instant case, section 2O proviso in its entirety is not violative of the provisions of the Temple Act. At the cost of repetition, we reproduce the relevant part of section 2O of the OE Act 1951 as under. Provided that all estates belonging to the temple of Lord Jagannath at Puri within the meaning of the Sri Jagannath Temple Act 1955 and all estates declared by it to be trust estate by a competent authority under this act prior to the date of coming into force of the Odisha Estate Abolition Act shall be deemed to be trust estate. It is only the first part of the proviso which is in contravention of the Temple Act 1955. If that part of the proviso continues to be given effect, section 5 and section 30 of the Temple Act 1955, by which the estate of Lord Jagannath Temple at Puri are vested in the temple committee, will lose their meaning. By striking down section 2O proviso, to that extent, both the provisions will be able to operate. So my respectful my lord, is that since section 5 and 30 has given an independent identity, my lord, and under a special statute, so it automatically flows, my lord. As per the judgment, it says there cannot be any mix of OE Act and this. However, the matter may be, but the temple administration applied under the OE Act, it is already recorded in favor of Lord Jagannath. Thereafter, in appeal also it is confirmed. So this, my lord, and your lordship, recording this, my lord,
down to this section 5 of this Sri Jagannath Temple Act 1955. Do you have a copy of this statute?
No, my lord.
I am happy. I can provide.
Just help. Mr. Tripathi.
My lord, it is the case that that property belongs to,
Read it.
notwithstanding anything in any other law,
Yes.
for the time being in force for custom, usage and contract, sonanda, deed or engagement of the administration and the governance of the temple and its endowments shall vest in a committee called Sri Jagannath Temple Managing Committee, constituted as such by the state government, and it shall have the rights and privilege in respect thereof as provided under section 33. It shall be a body corporate having
That is
perpetual.
the character of the temple committee, because for different purposes, its character has to be identified some way.
Yes,
for
ma'am.
purpose of income tax and other things. So they have stated that. The first line, when this non-extant clause is coming up, it says notwithstanding anything in any other law for the time being in force. Customs, uses or contract, sonot, deed or engagement.
Sonata, deed of engagement
Yes.
and administration of the governance of the temple, all these things. My lord, my humble submission in this respect.
All endowments will be in best. Yes,
Yes, my humble submission in this respect
yes.
is that the property did not belong to the Lord Jagannath of Puri. It was a Motha property. It was recorded in the name of Motha.
You read your own plaint, Mr. Tripathi, what you have stated. The deity of the mott is Jagannath, and what is the status of this Mohanto of the mott?
Because in Puri town, number of mothas are there. In all the mothas, Jagannath are the presiding deity.
You just come to your own plaint.
Yes,
we cannot go beyond that now. Annexure 10 is your plaint. First, second paragraph.
My lord,
Second paragraph of your plaint. Please read at page 59 of the writ petition.
that the disputed
This is
property
your admission.
is a civil suit is now pending. That is the TS number 442 by 96, annexure 10, 59,
Yes.
page 59 is the plaint. That suit is pending. In para 2, that the disputed property described in schedule A as shown in the sketch map of the plaint originally belonged to Kottarapa Motho.
No, my issue is somewhat different. Is a pending not. This is your plaint.
Yes, ma'am.
Whatever you say in the plaint is your admission.
Yes, ma'am.
So this is why I am telling you, read this paragraph 2.
Paragraph 2 of page 59, my lord.
59, yes.
Page 59, paragraph 2, the disputed property described in the schedule A and shown in the sketch map in the plaint originally belonged to Kottarapa Motho, having a branch at Puri, the property was recorded in the name of Sri Jagannath Mahaprabhu in the intermediary status. Then para 3,
Yes.
that the disputed property along with its adjoining area was laying fallow and unproductive.
No, that is a separate issue.
Para 2 says, Jagannath Mahaprabhu of that motto was the owner. That motto. It was not the Lord Jagannath of Sri Mandir.
It is very difficult. Jagannath Mahaprabhu has different entities in the state of Orissa.
Even
or is the single entity?
in all over country, in many places, Lord Jagannath is being worshipped.
So far the act is concerned, can you define this? This is a different kind of a
Amrutamani status. It
entity or
is
not?
Amrutamani status. Status is Amrutamani, my lord. The property, my lord, it was under the Markodarship. Now, after this act came into force,
No, that is why I am telling you.
yes, yes,
Deity is the owner of the whole property
Yes, yes.
in the ordinary parlance of the property.
My humble submission is that Section 5 of the Temple Act is not applicable because the property directly did not belong to Lord Jagannath of Sri Mandir. It was the property of a motto by way of it was declared as trust estate in the year 1967. In the year 67, a tribunal constituted by a tribunal judge held that this is the trust estate of the motto. So, a managing committee, the trustee will be the owner of the or manager of that property. Accordingly, the trustee instituted a case against me under Section 25 of the Endowment Act, saying that I am in illegal possession. Possession be recovered in favor of the motto. That case was agitated before the Commissioner of Endowment. Commissioner of Endowment allowed that prayer. Against that, the father of the petitioner, agitated challenged it before this honorable court, which has reported, my lord, in the year 1970, CLT. That was, it was the honorable court differentiated the property which was Amruta money of 2 types. There is difference in that decision, 2 types. One is directly recorded in the name of the Lord Jagannath of Sri Mandir. Another is Amruta money recorded in different places in name of different institutions and different individuals. Those properties cannot be equated with the property which is directly recorded in the name of the Lord Jagannath of Sri Mandir. That was the difference.
You are bringing this concept very well good. That you just tell me that one thing, the endowments are made in whose favor? In the different mottos. In favor of this Lord Jagannath or someone else? That is the issue to be ultimately decided.
So far as the Lord, so far as the Jagannath, the temple authority is concerned, in the year 1974, kindly take a glance to page 10 of my writ application, page 10. In the year 1974, the state government filed a the state government brought a notification saying that all the trust estate, including the estate of Lord Jagannath, vested in the state government. Thereafter, that notification was challenged by the temple authority before this honorable court, and that writ application was OJC number 233/77, page 11 of my writ application. I have stated in the year 1977, the temple authority had initiated a writ application that was dismissed, and against that the temple authority again went to the Honorable Supreme Court And Supreme Court held that notification is valid. That was also a reported case in the year reported in AR 1989 Supreme Court, page 464.
Just would you come to this paragraph 4.1 of your writ petition?
Yes, my lord. In the year 1890.
After this plot numbers and area,
Yes.
you come to the paragraph after that paragraph.
As per the entry in the relevant settlement record, a record of right, the status of the land has been described as Amrutamunai, and Amrutamunai is a special term for grant in the endowment of the Sri Jagannath Temple at Puri. In Daljel settlement report, land described as Amrutamunai has been referred to as property of Lord Jagannath. In Purnachandra Odia Bhasakosh, property described as Amrutamunai has been described as the property dedicated to the Seva of Lord Jagannath Puri by an order of the OA Tribunal on 21/12/67. The property in question has been declared as a trust estate of Khaki Akhada Matha, passed in miscellaneous case number 2874 of 1967. Then 4.2, 25/1/1950, by virtue of registered permanent lease, once Sri Mahanta Anadi Ramdas, the then Mahanta of Khaki Akhada Matha, as Marfadar of Sri Jagannath Mahaprabhu, transferred the properties described in the proceeding paragraph in favor of father of the writ petitioner on acceptance of the salami of rupees 500 and subject to payment of annual rent of rupees 100. A xerox copy of the aforesaid registered permanent lease deed is annexure 1. Then 4.3, on 21/12/67 in miscellaneous case number 2874/67, on reference made by the collector under chapter 2A of the OA Act, the tribunal judge recorded a finding. As seen from the particulars furnished by the collector, the estate stands recorded in the name of Lord Jagannath and is managed by a Matha. I am satisfied that estate is a trust estate and hereby declared it to be so. Then on 1969, 22/11/69, the then interim trustee of Khaki Akhada Matha, Puri, filed an application under section 25 of OHRA Act before the Commissioner, Hindu Religious and Endowment, Bhubaneswar. The aforesaid application was registered as OP case number 39/69. The contention in the aforesaid application was that the property belonged to Khaki Akhada Matha, managed by Mahanta pursuant to the scheme settled under OHRA Act. The management of Matha was vested in the Board of Trustee. The property in question has been transferred in contravention of section 58 of 4 of 39, corresponding to section 19 of Act 2 of 1952, and sought for recovery of possession under section 25 of OHRA Act. For the purpose of ready reference, the copy of aforesaid application is annexed here to annexure 2. Then 5.4.5. On 9/4/70, the then Commissioner Endowment passed an order that the transaction is hid by section 19 of the OHRA Act and directed recovery of possession under section 25 of OHRA Act, and issued requisition to the collector, Puri, to effect delivery of possession of the land in favor of the interim trustee of Khaki Akhada Matha. The relevant order of the Commissioner Endowment dated 9/4/70 is annexed herewith as annexure 3. Being aggrieved by the aforesaid action, direction under section annexure 3, the father of the present petitioner referred OJC number 894/70 before this honorable court, that on 14/8/1973, the honorable court disposed of the OJC number 894/70 with the following findings. The property in question of Amrutamunai of Lord Jagannath Puri, Amrutamunai property
my lord.
Oh,
It's not noticed. We have not noticed, my lord.
I think the issues is a little bit of gap in the facts are available. And the records are not responding to that gap. The gap is that first of all, there is no confusion about that whether the lease, the settlement, everything is clear, it is covered by section 5. Only issue is finding that whether this is the endowment of the Lord Jagannath or not. That is the issue. In the plain, they have in a different way, they have described the nature of the property. Their case is that it was the mortals property and it was controlled by a trust created under the Hindu Endowment Act. That is your case.
Yes.
So therefore, the section 5 will have no sway over this property. So I think you should file a affidavit in response to the limitation application. We are issuing notice on that limitation application.
On limitation, we will file an application.
Because it's very difficult. It is so many of inquiry into the
Besides that, also, my lord, my responsibility for my lord is that. This is a revision, my lord. Alternate of the remedies available.
That is why you raised that issues is. Then if you find that it is actually not a matter that can be decided under Article 226 or for that matter 227, he has to go other forum, will not decide it.
Yes,
so file a reply. We issue notice, I think the facts should be brought out properly.
The writ will be restored, my lord.
Huh?
We will file objection on limitation. Since it is
all the opposite parties have been noticed.
the other parties, my lord,
Noticed in the restoration case.
No private parties are there, my lord.
Oh, then state is there for 2, 3, 4, and 5.
3 and 4 years. 5.
And 1 is already there. So
yes.
You're in IA number 348 of 2019. So there is an application for condoning the delay of 1,400 days as per the stamp report in filing the restoration application being same application 864 of 2019. For restoring the what is the repetition number? WPC number 14709 of 2006. Issue notice. Mr. A.K. Tripathi and Council appearing to the.
May be directed to serve the copy.
Huh?
I may be directed to serve the copy that will.
No, obviously. So issue notice returnable on 21st to next 22nd, no? 22nd of February 2020. Very sorry, September 2022. T3. Since Mr. who are appearing now?
He is appearing for opposite party number 1.
1.
Have you filed your appearance?
Today I filed.
You are appearing for 1.
I am for OP1.
And Mr. Mudali, you are appearing for 2
to 5. 2 to 5.
My lord and friend,
what is his good name, sir?
Subrat Satpathy. Subrat Satpathy.
Sri Subrat Satpathy and council appears for the opposite party number 1, Sri Jagannath Mahaprabhu, Marfat Sri Mandir Puri Chalana Committee to the administrator of Sri Jagannath Temple Puri and Mr. T.K. Muduli, an additional government advocate, appears for the remaining opposite parties. So we request Mr. Tripathi Land Council appearing for the applicant to supply the Land Council for the opposite parties to supply a copy of the application, condonation petition, along with a copy.
I have already.
I am having that copy.
I have already served.
So the council for the opposite parties have already received the copies of the limitation petition, condonation petition, and also the copy of the restoration petition. So by the next day, the opposite parties may file objection if any. It is made clear no further accommodation will be made. Because only bring the fact, because there is something really disturbing fact. Because of some order has been passed by the settlement authority.
My lord, fixed a date, my lord?
22nd.
20th.
The matter was there on 18th, your lordship. So my lord, on the basis of the submission made, the matter was kept to 25th, could not be listed. Now it is before my lords. In the meantime, they filed a reply. It is regarding compliance of a lordship order within a stipulated period.
Yes.
Now, my lord, they have issued a notice to me on 23rd of last month,
Yes.
which I have in the meantime complied, demanding some certain information, which I have already complied on 5th of this month.
Have you produced that you have complied this?
Compliance, today I got it, I will file an affidavit, your lordship. And in the meantime, my friend can take instructions.
What happened, Mr. Shakapatri?
Yes. You have received this. I'm not giving you this copy. I'm not at moment guy giving you this. I'll file it by Monday, your lordship may take it next week. It is regarding fixing a time limit, my lord, in order to give effect to your lordship's order. That was in January this year, it was passed. Today we are already in September. We are running a bank, we are not getting the benefit of the order.
It was. No,
Mat-
if you-
Matter was kept pending. So they say now on 23rd, after your lordship issued them notice that they have issued a notice that you have not complied, you have not given this information and all that. That we have already done, though it was there before them while making the assessment without entering into the dispute. We complied the same on 5th of.
Is it required that any further orders to be passed here? Because you have complied and they have,
I wanted
they
your
have to implement.
Yes, yes.
your lordship may
there are
say
some-
let them implement within
No, no,
7, 10 or 15 days.
There is some difficulties here. The returns has been filed in some other form. And now he has, in appeal, they have changed their procedure. Now in this honorable court directed to give exemption under 80P, though there was no claim earlier in the filing of return. Therefore, now everything is going to flow from the NAT process. So when this issue is been accepted, it's not accepted by the portal. Therefore, I am asking some documents so that it can be settled it out. So now he has been up, and you'll also have stated in my para that.
No, that you are arguing now.
No, we are not
That
staying.
is-
We are not
that is-
stand in the way.
That is never disputed by you.
Yes, no.
So you have to accept, you have accepted our judgment or the order.
Yes.
So he is to comply.
Yes.
Whatever you have asked.
Yes.
He has complied with. You have to take a decision.
Definitely.
As per the order passed. by
Definitely.
this
That is
court.
what
So
I
any
understand.
Further order
No.
is required to be
No,
passed here.
not at all, not at all.
That is what I am asking.
Not at all.
Subject to what
Yes.
Honorable Chief Justice would say.
That is my impression also, that since he has complied with all the information, you take a decision.
No,
And
he's
his
now- he's
only,
now- he's-
only anxiety is that you may take more time. So there should be a time. frame.
9 months has gone by.
Already fixed 6 weeks time, you decide it.
Subject to Milord, is to comply the query
Yes.
made because of this situation. I will not stand on the way because earlier.
Query is being raised in August.
Now, we will simply, I think, Honorable Chief Justice will agree, we will say that we will cooperate with the
Yes, that is what-
department and department
Yes.
would pass the necessary,
yes.
take a decision
Yes.
necessary in this matter
Yes.
within 6 weeks. What?
Yes.
6 weeks is a long time, but we are.
No, Milord,
continuing.
6 weeks.
6 weeks is a long time.
No. Because there is some.
Looking at order was of
there
9th
is
of
a-
January.
This order is of
9th of January.
Thereafter, continuous process is going on.
No,
Not that we are
this
stand.
first
Yes,
demand we received in 23rd of March, August, my lord.
And you are already refunded.
Beyond statutory period also you have taken.
But this is the situation. We cannot comply because of some technical glitches. We are
Anyway,
not-
whatever is there, that is your lordship may direct. And if the period could be shortened also, my client will be happy, my lordship. Subject to my lord's appreciation. This is not in recorded, my lord. This is the,
No, that is the problem. Actually, nothing is on record. What is that order of this court? This is the 1st January, 9th January.
yes, my lord. That was passed in, my lord, in the second item. That is the original case. First and third items, your lordship followed that case, relied on. Second item, my lord.
ITA.
ITA.
ITA 113 of 12.
Here. This is a combined orders.
My lord, for different years.
Now, which one you are concerned with in this writ petition?
All the three, my lord.
All these three.
In the second item, my lord, the order is passed and that has been followed by your lordship in the first and third item.
I think Honorable Apex Court has confirmed this Gujarat High Court judgment.
No, but that judgment I have not.
We have followed. We have simply followed Gujarat
Yes,
High Court
yes.
judgment.
That is the fact is different. So
Maybe that you have to take a decision.
now it's over, so I cannot respond the same.
But the court did not apply that you are is a deficiency of giving the informations to them.
No, that was not there. Now they have raised it in August this year, that I have not supplied them the necessary information. They for the first time write a letter to us. Please refer to the Honorable High Court's order dated such and such. In this connection, the Honorable High Court has directed to give additional deductions of such 10% on bad and doubtful debts. During assessment proceeding, AO had asked to submit details of branch-wise loan details to determine aggregate average rural advance by you, who have failed to submit the same. You are therefore requested to submit branch-wise loan details to enable this office to give effect to the order of the Honorable High Court. This is the letter they issued on 23/8/2023, pursuant to my repeated request. And we have complied to the same on 5/9/2023.
I think all the records have been placed in the record. One thing, you file, we are fixing the matter on 15th.
My lord.
In the meanwhile, you brought all the communication on the record before us.
Yes, your lords.
That proceeding, we have not staged. You continue.
You may continue and
Yes, yes.
if it is permissible, you may close it.
It can be disposed of there.
Yes.
Or 6 weeks, your lordship is saying, let them take a decision otherwise.
No, they are in the process. They may
Then we
close
don't
it.
get
on the
any
process.
reference to anything.
We are on the process. We are in the affidavit stated that it is pending and we are.
Stated this required information furnished by the SCCB and this revenue is directed to complete the entire proceeding by 6 weeks.
Yes.
Nothing we are mentioning, no
Yes,
fact and
no,
nothing.
yes.
is said.
That's not.
There's
I
some
think.
gap I find, okay. And Mr. In all the matters here, there, no?
My lord.
Mr. S.K. Sarangil and senior counsel,
SK sir. He is also SK.
D.K. Behra.
No, he is SK Sarding.
Sudeep Kumar Sarding.
Sudeep Kumar Sarding.
Yes. Sarangil and counsel. And also heard Mr. T.K. Sataputil and Senior Standing Counsel IT. So it has been stated by Mr. Sarangil and the Senior Counsel that SSC has furnished all requisite information/papers to the revenue. Stop. The matter can be decided in the light of the decision of this court passed on 9/1. Order has been passed on 9/1 in
My lord, my lord.
9/1/2023. So, to shorten the life of the proceeding, this court may also take up a time frame. So, Mr. T. Shotamutil and counsel has fairly submitted that if 6 weeks time is provided to the revenue, they will pass the order whichever is appropriate in the circumstances. This petition stands disposed of in the following direction. As the SSC has filed the requisite information as papers, the proceeding shall be completed in a period of 6 weeks by a reasonable order. So, we are not giving any further information required, nothing of that sort. So, there should be no orders to question. All the matters same orders. It's okay.
Pursuant to letter dated 23/8/2023.
As required yesterday, pursuant to letter dated just as required.
23/8/23.
Yeah. As required by the letter dated requisite
No,
information.
not on record.
That is not in record, Lordship. This letter was not in record.
I'll file.
No, that is why.
That is your letter.
Yes, I understand, but that was not in the
You
record.
filed that letter by a memo.
I am filing that by memo.
Today, as required by the letter dated
23/8/2023.
23/8/2023. A copy of which has been filed by memorandum by Mr. S.K. Sarangil and counsel according to the petition. All right.
Yes.
Next.
Item number 4. May I please, your lordship? Lordship, I have filed an interim application praying therein to extend it the time period granted to the petitioner for appearance before the Tahsildar, my lord. What has happened, my lord, while disposing of the writ application, my lord has quashed the expiry order passed against me and directed me to
appear before the Tahsildar on a particular date. Now he is seeking extension of time. Because he could not appear on time.
And I was 60 years old and due to
All right, when you can appear, tell us.
Your lordship, the time period for disposal is 4 months. That may be kept in entire. He was supposed to appear on 1st March. Let him appear on 1st November.
Yes, ma'am.
And within 4 months, that will be disposed. Only to that effect, the order can be modified. He will appear before the Tahsildar.
This is the purpose of filing the writ petition.
My lord, I have filed an interim application, my lord.
No,
Writ petition was disposed of by
direction.
All right.
Flat 10.
Yes.
Like 10, yes. Okay, this I number 13062 of 2023.
13062 of 2023.
All right. Heard Mr.
My name is Amit Kumar Patram.
And also Mr. D.K. Mohanty, an additional government advocate. By means of this interlocutory application, the applicant has prayed for extension of time for appearance before the Tahsildar Khurda to in the suo motu lis mis case number 37 of 2000 in terms of the order dated 12/1/2023 passed in WPC number 14351 of 2014. So, in the said order, the applicant was directed
To appear
before the Tahsildar on 1st March 2023.
Tahsildar Khurda.
Tahsildar Khurda on 1st March 2023. But the applicant could not appear for unavoidable circumstances. Mr. Mohanty Learned Council has fairly submitted that a fresh date may be fixed, but the time for disposal may be maintained. As such, we direct the petitioner to appear on 1st of November. Is a working day, Mr. Mohanty.
Yes, 1st of November. Is a working day. Yes,
Working day, 1st of November. 1st of November 2023. Without fail. So the Tahsildar shall dispose of the proceeding within 4 months from the date of appearance, i.e. 1st of November 2023. In terms of the above, this application stands allowed to the extent that indicated above. There will be no orders to cost.
I'm grateful, ma'am.
Item number 5.
The IL number 1092 of 2023 for praying for recalling of the order dated 4/1/2003 is not pressed, my lord.
Not pressed.
Not pressed. We only pray that the new transferee.
All right, we are simply recording not pressed. Here, Mr. Acharya.
Yeah, yes.
Mr. K.K. Acharya and counsel appearing to the applicant. The outset stated that he has instruction to not place this application, which has been filed for recalling which has been filed for recall of the order dated 4/1/2023. As passed in WPC number 11796 of 2016.
Lordship, in keeping with the order, last order dated 4/1/23, the new transferee may kindly be permitted to execute the same cause of action in a fresh petition.
No, that you cannot say, because if you simply say that I have been instructed to not place this thing, will not grant any liberty, it will be just dismissed. If you want to liberty, then you have to give them the opportunity, because whether there is anything to be adjudicated or not, that we cannot do in this way. Just simply says it is dismissed as not placed.
That has been already ordered, my lord, in 4/1/23 order.
That is the order.
That remains. That
prevails.
we cannot recall.
Only thing, my lord.
No, that we cannot change.
No, okay.
We can't change. Because we are withdrawing this.
Because the last order says petitioner. Petitioner doesn't exist anymore after the CIRP.
So that we cannot
that is a separate issue. Whether the petitioner exists or not, petitioner existed on the day of filing the petition.
Yeah.
And if there is any change, it is your responsibility to get the persons who has taken over to get the substitution. Otherwise, court will pass the order as on date when the cause arose. Accordingly, this petition stands dismissed as not placed. All right, Mr. Radhisham Chimankar and the Senior Standing Counsel for GST and Central Excise Department appeals for the opposite parties.
Item number 6.
I am appealing for the respondent number 4, and expertly order was passed restoring the recovery, and the recovery which the order was passed is totally wrong. Your Lordship will kindly see the order dated 28/2/2020.
Just a minute, please.
For each matter, I have filed an application for recovery.
What about your limitation application?
That is condone expertise. Limitation and application condone expertise. The recovery was also discovered.
No. All right. Oh, you are here appearing for whom? Appellant?
My lords, I appear for the appellants.
I am appearing for the respondent number 4, my lord. I had an application to recover that order.
Because you are not given notice.
No. There it was listed, here was condemned, the order was passed, and the order is also wrong, man.
Wrong or right, we are not deciding right now.
My lords, the remedy lies some.
Judge has quashed the mutation proceeding. Here, my lord, the order reflected that it has remanded. The order which was challenged in the writ appeal, my lord, the proceeding was quashed. And the order is that, my lord, it was remanded.
If I may submit, my lords.
The appeal will go later on, but is it true that the limitation was condoned, this delay was condoned without notice to the other side? Because there is a huge delay, 274 days delay.
Yes, my lords, no notice was issued, my lords.
So?
My lords, the issue was this, on the first date of hearing, my lords, the order that has been challenged by way of IA, in that order, my lords, on the first day itself, the court disposed of with a direction to the collector Puri to continue with the proceedings and expedite it. So, my lords, the delay, and that has attained finality. Now, my lords, by way of an IA, this order has been, the prayer is to modify the order, my lords. So the IA, my lords, is not maintainable.
Order dated 28th.
Because this honorable court in the first round has finally disposed of. And after the disposal, pursuant to that, the collector Puri was directed to expedite the proceedings. He is also conducting it. It would have been over by May. In between, my lords, they have filed an IA. I think my learned friend will allow me to submit. The prayer, my lords, of the IA, if your lordship see, is calling for modification of the order. And modification of the order and to quash the proceedings that is happening. So it is in fact an appeal, my lords. And there is no remedy which can be called in an IA where the High Court, Honorable High Court has finally disposed it of. The remedy lies either in a SLP or at least in a review. So my point is, my lord, this IA is not at all maintainable.
That may not be the entire position. Just I'm reading out, give this CPC. I'm just reading for your benefit. What the CPC says, because we adopt the principles of the CPC, this is Order 41, Rule 21. Re-hearing on application of the respondent against whom ex parte decree made. But there is an issue that will coming later. Where an appeal is heard ex parte and judgment is pronounced against the respondent, he may apply to the appellate court to re-hear the appeal, and he will satisfy the court that the notice was not duly served or that he was prevented by sufficient cause from appearing when the appeal was called for hearing. The court shall rehear the appeal on such terms as to the cost or otherwise as it thinks fit to impose upon him. So here is a case we can hear when the notice was not served or it was an opportunity was granted, but condition precedent is that the decree has been passed against you. But here only the single judge's order has been affirmed and finally see the come to the judge.
Here, the appeal court has said that the proceeding is pending and it has reminded by the running sitting judge.
Now just come to that order. That is my brother was showing me. Yes, yes.
My application operation of the order has been stayed.
28/2/2003, my lord. 2023, my lords. 28 February in written 1/6/2000.
Your lordship will kindly turn to the order which was passed by the running single judge at case
Now we are at order dated 28th February 2023.
Yes, my lords. Yes, my
Where I
lord.
was one of the parties.
That's the order, my lords.
Paragraph 3, you place it.
Paragraph 3.
Yes.
Yes.
Paragraph 2, I am placing.
No, paragraph
Your
3.
lordship,
Paragraph 3 is the operative part.
Correct, my lords.
That is the operating part based on paragraph
2 has nothing to do.
Paragraph 2, my lord. Here, my lord, by input order, the Honorable Syndicator of Judge has relegated the appellant to statutory remedy of an appeal before the sub-collector against the initiation of the procedure of mutation appeal number 1. So,
That's only a statement of.
paragraph 1, that is wrong. It is not being relegated. The proceeding has been passed. And the applicant was the opposite party in the writ petition. I was the petitioner in the writ petition.
Is the
And
order?
now I have kindly see the input order on which writ applies.
My lords, may I read paragraph 3 of the order? Because that is the relevant. That is the operative portion. While the court would not like to interfere with the impugned order, since it is only one of relegation of the appellant to the statutory remedy of an appeal, the court nevertheless directs the sub-collector will proceed in accordance with law and after hearing the parties dispose of the said appeal not later than 1st May 2023. Copy of the order may be sent to sub-collector Puri forthwith. Writ appeal is disposed of. An urgent certified copy of this order may be issued as per rules. So, my lords,
That appeal was
that
passed.
does not exist. It has been
That it is an abuse of process of court.
authority as per the act to proceed. And there, my learned friend
It was
will get.
not remanded.
And if my lords, if my learned friend is
Totally wrong order.
remedy lies in filing an SLP, my lords, or at least a review by way of an IA, just to recall the order. The whole spirit of the order cannot be turned. This is an IA, not an appeal. That is my objection, my lords.
Your lordship will kindly see the input order passed by the learned signature in WPC number 6144 of 21.
So for that, your lordship must look into the maintainability of the IA. Whether after attaining finality by a division bench of this honorable court headed by the Chief Justice, can it be reversed by way of an IA? That is a legal question, my lords. So this IA is not at all maintainable. It's a wrong abuse of process.
No, I is filed for reopening of the appeal and then on the appeal to be decided on
My
merit.
lords, in effect, what
If it is ex parte order,
yes, my lords.
Recall provision is there. That is inherent in every court.
But the these are also represented, my
It is
lords.
a para 11 something. I don't find this bench is correctly written. True, it is that the petitioner can appear before the sub-collector Puri.
Correct.
With the questions with regard to the maintainability of an appeal by filing appropriate application objection to the said appeal. But this court in exercise of power under Article 227 is not precluded from entertaining the writ petition when there is apparent abuse of process of the court.
And goes on and was the proceeding because it is an abuse of process of court.
And quash is the same, right?
And this was challenged by when
And
Supreme Court gives
the division bench of this court and there that it was remanded.
Actually, this para 11 gives the initial impression that all right. Now, his name is
Unikrishna. Where Mr. Krishnan, right?
You are not audible.
My lords, I am J. Krishnan. My lords can hear me?
Yes.
Yes. So my lords, my point was this IA is not maintainable because this honorable court has finally disposed of the matter, directing the statutory authority, the Puri collector, to proceed with. And all the contentions can be raised there, my lords. So there is no natural justice violation has happened. But by way of this IA, if your lordship see the prayer, it's very interesting. Prayer of the IA, page 6. It says, under the facts and circumstances as stated above, and the facts is only facts, my lord, no grounds are there. This honorable court may be graciously pleased to allow this application, and the order dated 28 to 23 may kindly be modified, holding that the appeal before the sub-collector Puri is not maintainable, and consequently the writ appeal be dismissed. So, my lords, that means the whole remedy has been asked in this IA. It's not only to modify the order. It is not only to modify the order or hear the other side. It is in fact asking for an appeal against that final order, my lords, of 28-2. Appeal lies somewhere else, my lords. In IA, for modification, you cannot ask a substantial relief of dismissal of the writ appeal. Because the all opportunities are open. This honorable court say that we are not interfering in the merits of the matter.
Mr. Krishnan, in the petition for condonation of delay, we have not issued notice to the other side, and we have condoned it.
Correct.
Only on that ground, we are allowing this petition, opening the opportunity for the respondent in the writ appeal. That's all we are doing.
Yes.
Whatever you argue on merit later on.
Your lordships want to give an opportunity again to contest the appeal on merits. Am I right?
Exactly.
No,
we are not modifying right now. First of all, we are restoring this appeal again.
Very right. I'm obliged.
I number 1577 of 2023. This is an application for modification of the order dated 28/2/2023. Is passed in WA 1621 of 2022. Stop. Ms. D. Mahapatra, where counsel appearing for the applicant has stated that there was a delay of 247 days in filing the writ appeal from the order dated 24/2/2022, passed by the Lani Single Judge in WPC number 6144 of 2022. But without notice to the present applicant, who was the respondent number 5 here. Respondent number 5 to all.
I am the private opposite respondent number 5. Yes.
Only 5.
Only 5.
Respondent number 5, they said delay was condoned. And the order dated 24/2/2022 was interpreted differently, causing serious prejudice to the applicant. We have heard Mr. Krishnan and counsel appearing for the opposite party writ appellant, and also Mr. P.K. Madhuli and the National Government Advocate appearing for the 1 to 4 opposite
1 to 4
parties number 1, 2, 3, and 4. All right. So, following the principles of Order 41, Rule 21 of the CPC. We stop. The applicant will be allowed to raise the question as regards limitation. Stop. Accordingly, it is ordered in main WPC. This is the matter on 22/9/2023. We are fixing on 22nd of September.
22nd is a Friday, my lords. Yes, my lords.
All right. Next. Yes. Ah, that is true. It's better. Mr. Majan, the retaping will listed before the assigned bench.
Assigned bench, no, the next week now.
41st September.
In the meantime, I can also hide my counsel.
Counter affidavit against the retaping. We are not open. We said that we have restored the retaping. You challenge that the maintainability of the retaping regarding limitation that I have not received. You file in a proper application there. We have not opened that chapter. You go to the retaping and say the order has been passed without hearing me. So reopen the retaping. We have not passed. We only restored the retaping. We cannot go. What impugned? Impugned order is set aside. Otherwise, how can we restore it?
My lord, the delay of your lordship, see, I will explain it when I get an
No, you
opportunity.
explain, but her grievance is very simple. He says, I did not get the notice.
Yeah.
More than 200 days delay. She had got a right to object it.
No, I
Yes.
appreciate.
Yes.
Item number 7.
I'm obliged.
May please. They have filed the affidavit, my additional affidavit, and explaining, yeah, I am not consciously avoiding the court not to present on 27th October 2022, my lord.
What
Due
happened? Avoiding the court.
27th
Oh, that-
October 2022.
When?
Due to my own illness, due to my dental problem, I could not able to come to the court. But the problem is that due to that, the date is consistent to the date of that strike, I do not know. So this thing is happening. Because I have sincerely unconditional apology that I have no intention at all.
Have you
Not
filed any application?
I filed application, my lord. I submitted additional affidavit and mentioning there, I have unconditionally sincere apology for non-appearance on dated 27/10/2022, my lord. I have no intention at all not to appear on that date. Even if I have intention, so on next I have regularly come to the court doing the work.
In the order, this. It is filed an affidavit like B. No, no, it's all. We have seen the affidavit filed by Mr. Jagmohan Patnaik and council on 23/8/20 2023. Mr. Patnaik has stated in his affidavit that he remained away from any court proceeding on 27/10/2022 for his sudden illness. And that is the reason why he could not appear. Also, before this court, when the order dated 27/10/2022 was passed by dismissing the writ petition being WPC number 7673 of 2022. We believe that the said statement is sincere and truthful, and in view of that, the observation is made in the order dated 1/2/2023. Is not considered for any further observation. Stop. As we have accepted the statement of Mr. Patnaik, Land Council, we close the issue of tendering sincere apology to this court. Stop. Then go to the CM application petition. Third, Mr. J. Patnaik, Land Council, appearing to the applicant. Issue notice. This is an application for recalling the order dated 7/7, recall the order. And restore the petition being WPC number 76 to its original. Issue notice is made returnable on 19th of October 2023. Are you appearing? Yes. So since Mr. R. Chimankal and the Senior Standing Council appears for the opinion, no formal notice is called for. Can we just restore the petition? He'll file objection? No. He'll not file objection. It should not. Just restart. Just scroll out and again. And this is a same application suggestion. This is an application for recalling the order date of suggestions and the consequent restoration of the WPC being suggestions. Issue notice. Mr. R.S. Chimankal, Senior Standing Council, for giving appears in which notice for the opposite parties and submits that the opposite parties do not have any opposition if the said order dated such and such is recalled and the petition is restored to its original file. having perused the reason assigned by the applicant and also appreciate and also on consideration of the concession is made by Mr. Chimankar and Senior Standing Counsel for reviewing. We recall the order dated such and such and restore the reparation number such and such to its original file. On the result, this application stands allowed and disposed. In WPC, this is the matter on 11th of October 2023. So, we put the roster, we put the assigned batch.
Item number 8.
May please the lordship. And here the writ petition has been disposed of by order dated 2/2023. Now directing that the execution case pending before the first additional to be expedited. There is no time limit has been fixed. So my lord, I have filed this IA for fixing a time limit so that it can be disposed of. In the meantime, 7 months have lapsed from 2nd February. It is now in September. The executing court has not, even though here it is a eviction, unauthorized construction by the opposite parties in a drain block.
No, it is very difficult to set up a timeline for execution case.
But here what has happened, the persons who are in occupation of the over drain, they have filed application before the court below stating that if they lose in the case, they will demolish the matter. That was also confirmed in the second appeal here in this honorable court. And they went up into the Supreme Court. That is also dismissed. Self-same, they have said that they will demolish. But here the municipality and those persons who are occupying, they are hand in gloves and they are not.
Where is the order?
Murder.
Last order of this court.
Order dated, I have quoted, 2nd February 2023. Here in paragraph 5, lordships have stated the CMC will also requested to the concerned court to expedite the matter. But both are hand in gloves, not disposing the matter. Lordship kind of glance, I have given a photo in the writ petition, how the condition of the drain. The people are suffering. Because of construction of unauthorized construction over the drain. At page 45, lordship kindly have glanced the photograph in the writ petition. The condition will be precarious. And now the rainy season is going on, Lord. Dengue is there everywhere in the Cuttack town.
Heard Mr. A.K. Patrol and counsel appearing to the petitioner. By the order dated 2nd February 2023, delivering WPC PIL number 2155 of 2023, this court had occasion to observe that the proceedings are already pending in another court since the proceeding. It would not be appropriate for the court to entertain parallel proceedings. A direction nevertheless is issued to the CMC to ensure that all the relevant orders, including those forming part of the present petition, are placed before the court of the first additional civil justice senior division, Kotok, in execution case number 80 of 2019, positively, if not already done, within a period of 8 weeks by filing a appropriate application in those proceedings. Mr. Patrol and counsel has drawn our attention that after passing of the said order, almost 9 months have already elapsed.
7 months. 7 months.
7 months have already elapsed. So, as such, he has prayed that a time frame should be set up for completing the proceeding before the first additional judge senior division is concerned. So it may be appropriate to note the said proceeding is related to execution of a decree of the civil court. Stop. Mr. Patrol and counsel has submitted that the dispute is a primarily centers around the construction over the
Drain.
public drainage
Yes, no.
system. Stop. For the unlawful occupation, the people of the locality is suffering a lot, particularly during the rainy season. So, be that as it may, we asked the civil court, i.e. the first additional civil judge senior division Cuttack, to take all initiatives to complete the execution case within a period of 6 months from the day when a order of this court will be placed in the proceeding.
But I may be permitted to place the order before the court below.
So for that purpose, we allow the petition applicant to petitioner. You are the writ petitioner.
Yes.
Writ petitioner to file a copy of this order in the said proceeding. Oh, stop. Mr.
assist the
Muduli,
court.
you are appearing for? Mr.
State.
P. Muduli,
State paid party.
Learned.
P1, 2, 1 and 2.
So the other parties are not noticed.
No, my lord. It is in the initial stage. On the day of admission, it was directed.
Okay. So P. Muduli, and counsel appears for the opposite parties number 1 and 2. So, in terms of the above, this application stands disposed of.
But I may be also permitted to assist the court in the court below, so that it will be disposed of. Because my lord,
That is the
both-
earlier observation is
Yes,
there,
ma'am.
that you can take.
Yes, ma'am.
We are not changing, only
No,
6
ma'am.
months we have given.
Yes, obliged.
All right.